May I pay, Lordship? I have to mention again item number 57 of today's list, Lordship.
57.
Lordship. In this another case, Lordship, arising out of same affair is listed in court number 24. In that case diary is available. So may I pay that learned PP may be directed to obtain the case diary at the time of hearing, Lordship? They can court number 9. Court number 24, item 9.
Or sir, you can get it, no? Okay.
May it please, your Lordship.
Yes.
I beg to mention item number 1, Lordship.
Hmm.
So may kindly fixed on Monday, Monday. This is hearing matter, Lordship. Wrongly listed for motion, Lordship.
The bail
Seat
application.
is available, Lordship. 1, Lordship.
Item number 1. The hearing matter.
Lordship. On Monday, Lordship, as hearing.
Okay, on the prayer of the learned counsel appearing for the applicant, let the bail application be listed on Monday in bail hearing column.
Oblige.
May I please, Lordship? Lordship, I'd like to mention item 33.
30?
33.
33, yes.
Kindly possible for the day, Lordship.
On the prayer of learned counsel appearing for the accused applicant, let the matter be passed over for the day.
Next, Lordship.
Passed over for the day, yes.
May it please your Lordship. Lordship, with consent of the other side, I beg to mention item number 37, Lordship.
Hmm.
This counsel, Mr. R.S. Misra, is out of station, Lordship.
Okay.
Adjourned for the day.
The learned counsel appearing for the
Item
accused
37.
applicant submits that the engaged counsel, Mr. R.S. Misra, is out of station. Therefore, prays for some accommodation. Let the matter be listed on,
Any day, Lordship.
listed in the next page.
Lordship, interim may be continued.
Interim order so passed earlier, shall continue. Give a date, huh? Give a date. Interim order is there. The matter is fixed, right? 18th, huh?
Lordship, I beg to mention item number 49.
49, yes.
Kindly, Lordship, fix the matter for next week on 20th February.
Okay, on the, yeah, Mr.
This week, yeah.
You are not there in the case.
It's engaged counsel.
You are not there in the case.
I'm not, Astrodeep day, my senior Astrodeep days.
Okay, the learned counsel appearing for the accused applicant submits praise for the matter to be listed on
20 February.
Huh?
20.
20.
20.
20th. Let the matter be fixed on 20th. Eh?
Lordship, in item number 55, an additional affidavit is filed. So allow me to bring it on record.
Okay.
May it please, your Lordship. Okay, for listing of an AB matter on Tuesday, man.
Hmm.
On the floor.
May I please your Lordship? I beg to mention two criminal petition for listing, Lordship.
Two criminal petitions for listing.
Yes, Lordship.
Motion.
Motion.
New matter.
New matter.
Okay. When?
On
Tuesday. Tuesday.
Another prayer, Lordship. Lordship, I beg to mention on with Lordship out of same affair with item number 51, supplementary list 51. Another matter is pending, Lordship. Kindly take this matter with item number 51, Lordship.
Pending where?
Lordship, file, Lordship.
Not listed,
Not
no?
listed,
Not listed, it will be difficult.
Lordship.
Okay. On the prayer of the learned counsel, you are not there in the case.
I am there, Lordship.
Your name is not there. Okay, anyways, learned counsel appearing for the accused applicant submits that another bail application. It is listed, not listed.
Listed, Lordship.
Another bail application arising out of the same FIR is pending before this court. Therefore, she prays that the same to be listed along with the instant bail application on Tuesday. On Tuesday, okay. And give the bill number.
I will provide.
You just provide him now. Make it fast. No, listing of debt application along with this. Oh, it'll come together. Item 551, we are passing an order to get that matter listed together.
Lordship, I was praying.
I am clarifying,
yesterday two matter my lord heard that Pronia my lord regarding one this NDPS case my lord.
Hmm.
One my lord has made it CAB, but other matter my lord I have took time my lord for today. That is this matter my lord. To verify my lord 48 my lord one Gambura has taken.
Let the matter come, then we'll see.
Yes,
Let the matter come.
And this matter is he is paying that matter is motion matter my lord. Number not don't know my lord. So that matter.
I mean, it is pending or it is not, it is filed, not filed. Huh?
Newly filed.
Newly filed, you don't mention like that. I thought the matter is pending, you have filed it. No, I mean, we'll not allow like this kind of submissions. You'll have to give mention memo. No, why you have not given mention memo?
I will
And like you said pending. What do you mean by pending?
May I please?
This
Your Lordship?
51, let the 50, I don't know, 51 come, we'll see then.
May I please, Your Lordship? Lordship, in item number 22, 27, my lord,
Mm-hmm.
we will file additional affidavit for default bail, my lord.
You have filed an additional
Yes, my
affidavit.
lord.
Okay.
Because on
No,
19
now what? Now it is, I mean, it is numbered.
Yes, my lord.
Oh, it's an additional affidavit. Okay.
Affidavit.
You can let them bring in.
Kindly record it, my lord.
You bring in.
Bring it, you give
No, my
a
lord.
slip.
And the matter may be fixed on 17 or 18, my lord.
Okay.
Which item you said?
Item
20.
27, my
Okay, on
lord.
the prayer of the learned council, let the matter be fixed on
17 or 18. For
18,
default bail, my lord. Kindly the word.
18th.
Highly obliged, my lord.
Lordship, recommendation item number 36, my lord.
Hmm.
Lordship, CD is not received, my lord.
See, item number 36, right? CD is not received in the instant case. Let the matter be listed in the next week on
Lordship,
19th.
Short date may be given.
On 19th.
That's it, sir.
That is submitted. So let the matter reach.
Yes, plus one.
They mentioned, no? Already mentioned.
Item 2.
May I please, your lordship? My lord, this is a regular bail application, my lord. The petitioner was arrested on 27/1/2026, my lord. FIR start from page number, my lord, 17, my lord.
NDPS.
My lord,
So we'll call for the CD.
my lord.
Heard Mr. So-and-so, the learned counsel appearing for the accused applicant. Also heard Mr. K.K. Parasar, learned APE for the state. This is an application you write, huh? This is an application for it. The matter relates to recovery of how much quantity?
20 numbers of
My lord, 1.05 kg of
sorry.
Yava tablets.
The recovery of 1.0 plus. Call for CD, let the matter be fixed on
May I pray on 23rd, my lord?
23rd, 23rd, so many because are there, 26.
26th.
Highly obliged.
A scan copy may be called for.
Hmm?
A scan copy of the records may be called for.
Okay. It's charged with that matter.
Yes,
Succeeded.
They heard Mr. So-and-so, the land council. Yeah, A.I. Sarkar, the land council appearing for the accused applicant. Also heard Mr. K.K. Parasar, land APP for the state. This is an application under so-and-so. Matter relates to allegation of trespass in the house of the informant. He killed, husband was killed. Trespass, house of the informant, and thereby killed killed the husband of the informant. Registry to call for the TCR in the instant case from which court?
Dhubri Fort.
Huh?
Dhubri.
Dhub-
SDGM, Sadar
SD
Dhubri.
SDGM Sadar Dhubri. Let the matter fixed on SDGM Sadar Dhubri.
Next, 27.
27, let the matter fixed on 27.
Yes, Lordship. Lordship, item 4 and item 12 out of same affair, Lordship.
Item 4, item 12, give me 12 also.
Item 12, Lordship. 12 is AB, Lordship. In item 4, page number 12 is the affair, Lordship. Regular bill 483, Lordship.
So we'll call for
Hearing
the
is same,
CD.
call for the CD, Lordship.
We'll call for the city, heard Mr. So-and-so, learned counsel appearing for the accused applicant, also heard Mr. KP Parasar, learned DPP for the state. This is an application under so-and-so.
From Bida, Lordship, 19 maybe.
Then you write, the matter relates to recovery of, 34 numbers of cattle. Full stop. Call for the CD. Let the matter be
Short
fixed
date
on.
will be from Bida Sali, Lordship.
Huh?
From Bida Sali, short date, Lordship.
Let the matter be fixed on, 25th.
Lordship, 21 may be given, Lordship. From Bida Sali, Lordship, 36 days, Lordship.
Already 36 days.
Yes, Lordship.
21, my lord.
21, Lordship.
21, holiday.
21 is Saturday.
No,
No, Saturday we not fix.
23rd.
23rd.
Yes, Lordship.
Both these matters, huh? This one also.
Here, Lordship, affair PS 11, Lordship, the owner of the cattle, Lordship.
Hmm?
So with interim,
No, both the matters, I mean, will heard together.
I'm for praying for interim, Lordship.
No, interim, no interim.
Object.
Let the case there come.
Yes.
My lord, the petitioner was arrested on 22 January, my lord. Today is 13 days.
Hmm.
23 days, my lord, behind the bar. The affair lost, my lord, the area manager, fraud control unit.
We will call for the CD, cybercrime.
Yes, my lord.
Heard Mr. So-and-so, learned, counsel appearing for the accused applicant, also heard, Mr. So-and-so. There is an application under so-and-so. The matter relates to, matter relates to alleged cybercrime committed by the accused applicant. Call for the CD, let the matter.
25th.
25th.
May I please your lordship?
Yes.
It's a regular bail application. This is regarding the recent, the news that has viral the social media as well as the other media platforms regarding the arrest of the jailer of the central jail. So here in the petitioner is the jailer.
Okay, we'll call for the CD.
Yes, my lord.
Heard
Court-
Mr. Rituraj,
WR
WR Medhi, the land counsel appearing for the accused applicant, also heard, Mr. So-and-so. This is an application under so-and-so. The case relates to, who is Konkon Bora?
This is one of the police constable who was arrested with the possession of the drugs. He is
Okay.
currently lodged in the
Matter relates to,
jail in Mori.
recovery of,
19 small packets,
19 packets of ganja,
small.
bracket cannabis from the position of one Konkon Bora. Konkon Bora is a police officer.
Yeah, he's a police constable.
Konkon Bora, police constable, from the premises, from the jail premises.
Yes, they were on duty at the
From the jail premises, jail premises. Thereafter, the superintendent of central jail was arrested. Let them, call for the CD, let the matter be listed on
23,
20.
23, my lord, since
23,
yes.
23, okay.
obliged.
Yeah, Your Lordship. Conducting counsel, Mr. N. Hassan is on like in another court, Lordship.
Who is conducting counsel?
N. Hassan.
Huh?
N. Hassan.
1 second, 1 second. What is the case?
Lordship, may kindly pass on the,
What is the
Separate
case?
writing,
You are there in the case?
no, Lordship.
You're not there?
He's in another court, Lordship. He's on like in another court, Lordship.
Arms act is there, CD is required, my lord. 7.
Timing.
What is his name? N. Hassan.
N. Hassan.
We'll call for the CD, tell him, huh? We'll call for the CD, we'll not
Lordship,
wait. Heard Mr. N. Hassan.
He will appear, Lordship. He has some judgment, Lordship.
Okay, pass over for time being. Motion matters, let them be there, let them be here.
UAP and arms act, CD has to be called.
May please, Your Lordship. Regular bail application, my lord. FIR at page number 16.
Heard
NBPS
Mr. So-and-so, learned counsel appearing for the accused applicant, also heard so-and-so. It is an application under so-and-so. The matter relates to recovery of
27.99 gram of suspected.
27.29 gram of
Suspected heroin.
suspected
Heroin.
heroin. Suspected heroin. Call for the CD,
25th.
data matter fixed on 25th.
Obliged. 9.
Wait, please, Your Lordship. Lordship. Regular bail application, Lordship. Under section 10 of POCSO, Lordship.
Okay, heard MS so-and-so, the learned counsel appearing for the accused applicant, also heard Mr.
Since 9/1/26.
Parasar, AP for the state. Is an application under so-and-so. The case relates to where is the FIR?
FIR is that, Lordship, translated copy. page
You
18.
you write only your good things and like don't write about your FIR.
Page 18.
18, Lordship, page.
At least case relates to a sexual assault on the minor daughter of the informant by the accused applicant. Let notice be issued on respondent number 2 to the registry as per the prevailing notification issued by the Gauhati High Court. Notice respondent number 1 is dispensed with as learned APP appears in the matter. Call for the CD. Let the matter be fixed on
Matlab,
2nd of March.
notice has to be filed. Matlab, 27 February.
27th.
February, matlab.
27 it will not be.
February, matlab. Notice to sab hoga lagna.
Let it be fixed on 2nd of February, 2nd of March. A notice has to be issued, otherwise it will not help. Otherwise, fixing also it will not help. Let notice.
Obliged.
10 and 15 arising out of same FIR lordship regarding the cattle lordship, the page 12 is the FIR. Seventeen cattle were seized lordship from a house of Abu Bakr lordship, that the AAB lordship, that item 15. From his house lordship, from his house premises law. And the document lordship all has been annexed regarding that. And the farmer lordship by profession, and for that he possessed that lordship. And as per the FIR, it says information regarding theft, but no such.
From the
Already
residence
she-
of Abu Bakr. Abu Bakr is the owner.
Already she's in custody, Lordship. Father's custodial detention might not be required. I'll cooperate with the investigation, Lordship, as and when directed to
He was arrested earlier also.
Lordship. And that I'm not sure, Lordship, that in that case, Lordship, I was never arrested.
No, I mean, bail was granted to him.
No,
Earlier.
Lordship, that was AB, Lordship, that.
AB.
Page 35, Lordship, my
AB.
name was reflected there.
So
Lordship.
again, you have done the same
No,
thing.
not at all, Lordship, some politically motivated, Lordship.
No political motivation.
No, Lord.
How many days you were there?
Lordship, 10 days, Lord. Local person of the same locality, Lordship, like, as and when directed.
But you were involved in all these kind of
No,
things, no? I mean,
no, Lordship, that is from
absolutely not-
resident law, from the residential premises of that Abu Bakr, Lordship. And he have purchased, duly purchased, Lordship. They says only information, Lordship. Now, I was not arrested during the time of transportation or lifting the cows, Lordship, cattle. It's from the premises from Abu Bakr Siddiq, Lordship, and he have all the valid receipt, Lordship, purchase receipts and all.
You
Lordship.
purchased for what?
That, Lordship, he is a farmer by profession, Lordship.
How many cattle you need for farming?
No, that. Farming, Lordship,
How many cattle you buy?
No, Lordship, that.
How many cattle you buy for farming?
Purchase slip.
The purchase slips are there, Lordship, everything, Lordship, that. There is no specific, Lordship, allegation that the cattle were taken from one particular place or from a particular person, Lordship. Or he was not caught, he was not arrested while lifting the cattle from roadside or some shed or anything like that, or while transporting also, Lordship. Those kept is just the information, Lordship, from them. As per is revealed from the FIR, Lord. Already arrested, Lordship, his statements were recorded, Lordship, as and when required, Lordship, I'll let you know. Nearby that police station, Lord.
Yes, Mr. Porter,
My lord.
you were arrested when?
Arrested on 4-2, Lordship.
4-2.
3 he was arrested, 4 we have produced, Lordship. I'll cooperate with the investigation, Lordship. Now, already arrested, his statement recorded, the cattle were seized, Lordship. From one resident, Lordship, that has been.
Heard Mr. S. Munir, the learned counsel appearing for the accused applicant. Also heard Mr. K. Porter, learned AP for the state. There is an application under so and so. An FIR was lodged on laws on 5/11/2025, alleging that the accused applicant along with another person, namely Abu Bakr Siddiq, had concealed 17 stolen cows at an undisclosed location in the Kent Mohimari for the purpose of illegal smuggling. On receipt of the information, police team went to the place and recovered. How many cows were recovered? 17
17.
numbers of cattle from the residence of one Abu Bakr Siddiq, who is also a co-accused in the instant case. Full stop. On receipt of the full stop, the cattle were recovered and sent to Gosala. Full stop. The learned counsel, if for the accused applicant submits that the accused applicant is not linked with any smuggling or transportation or smuggling of cattle. He submits that the cattle were in fact genuinely purchased by the aforesaid Abu Bakr for his personal use in farming. He referred to the purchase receipts, sale and purchase receipts issued by various sellers from Jur Himuli Weekly Bazaar, post office Topar Pothar, Kamrup, Assam. He submits that the accused applicant is already has been arrested on 4th, and he was sent to judicial custody. He was sent to judicial custody on 5th of February, and since then he is behind the bars. He submits that he has been already interrogated and his statements are recorded, and therefore there is no necessity, there is no apparent necessity at this stage for further custodial detention. Full stop. The learned EPP, on the other hand, opposes the bill, considering considering the materials brought before this court, and after hearing the submission made by the counsel preparing for the respective party, this court reserved the opinion that the accused applicant should be granted bail at this stage. Full stop. Accordingly, it is directed that the accused applicant shall be released forthwith from jail on furnishing of a bail bond of rupees 30,000, with a security of like nature, subject to who?
CGM, Amingaon, Kamrup.
CGM Amingaon Kamrup, subject to the following conditions, put 3 conditions are non-normal conditions, that he will appear and all these things. And in view of the aforesaid direction, the instant bail application is disposed of.
He be the owner lordship of that.
You read the same thing, is AB application, FIR is same, FIR that reflects the same. Then you write that the learned counsel submits that the accused applicant, namely Abu Bakr Siddiq alias Bakr Ali, has in fact purchased those cattle for his personal use, and he is no way linked to any smuggling or illegal transportation of cattle. Since the co-accused has been arrested by the police, he is also apprehending arrest. Therefore, he pays anticipatory bail. Full stop. The learned APP, on the other hand, submits that opposes the bail application, opposes the AB bail, opposes his bail, opposes his bail. This court, after consideration of materials brought before this court, as well as after perusal of the receipts, perusal of the sale purchase receipts, is of the considered opinion that at this stage the accused applicant may be granted the privilege of pre-arrest bail. Accordingly, it is directed the accused applicant shall be released on bail on furnishing a bail bond of rupees 30,000 with security of like nature in the event of his arrest by the arresting authority. Full stop. Arresting authority subject to the following conditions: that the accused applicant shall appear before the investigating authority within a period of 10 days, and the accused applicant shall present himself as and when called for by the investigating authority and fully cooperate with the investigation. An accused applicant shall not try to that you write that shall not try to temper or hamper it. In view of the aforesaid direction, the instant bail application is AB application is disposed of.
Much obliged, your lord. Much obliged. 51.
Actually, yesterday I have already plead before this honorable court that in the instant case, all my constitutional mandates,
Yes,
Yesterday's matter.
Yesterday's matter, my lord.
all my constitutional mandate with regard to 47, 48 and 36 BNSS, that is the arrest memo, has not been complied with.
Regarding 48, my lord, that Gambura Asif Sheikh has taken the, my lord, already seen in the court. But regarding 47, yes, my lord, the 47, the signature is not there, my lord. I have talked with the, my lord, IO also, my lord.
47, I have annexed a certified copy, lordship, in page 31.
Sure.
Page 30 of my petition, wherein the signature.
Table of bottom matter order task plain body.
Otherwise, only 47 malat,
47 as well as the
47 where page?
page 30, Lordship. There is signature of arrested accused, which has been kept blank. It has not been served to me. Page 30. Otherwise, Lordship, in
Carota case locally Pascos Kata but related similar as lecture is other case to us. Locally, no, it was a Pasco interval. Okay, we'll consider your case because yesterday we have already dictated the other case.
yes.
So we'll not spend time dictating here. So we'll pass an order.
Lordship, with regard to the arrest memo,
Hmm?
my one last submission is that the arrest memo, wherein my signature has been obtained in some vernacular language,
Hmm.
this also goes against the mandates of Mihi Rajesh Shah, Lordship, wherein it has stated that particulars of the case has to be served in a language understood by the arrestee. Here,
You don't understand.
no, Lordship.
Hmm?
I don't understand English.
It's true.
I am a pawn shop vendor by occupation.
But you can involve in, drug trafficking and huge cultivation of drugs, but you do not understand the language.
Lordship,
But anyways, we'll pass an order. You do not understand the language, you do not know why you have been arrested, right?
Lordship, that is not the thing. The thing is, my
Next case, go.
Also have the diary, madam.
Heard Mr. N.J. Pratta, learned counsel appearing for the accused applicant, also heard Mr. Parasa. This is an application under so and so. The case relates to recovery of how much?
1,286 kg of morphine.
Huge quantity.
wholesale.
Yeah, I am a passenger in the train, madam.
Yeah, that's so and so. Call for the case diary. Let the material fixed on
24, 25th.
24.
25th.
So we'll find the FIR at page 11. The relevant portion starts at 12.
What is the allegation?
You know, that person who got drunk and he tried to enter in trespass into the house of one of my neighbors, my lord.
Hmm.
Subsequently, he was caught by all the villagers
Hmm.
and he was tied to a tree and he was beaten up, my lord.
Hmm.
Subsequently, my lord, that person died. That is the allegation, my lord. Now, one of the things, my lord, I am a neighbor of that person, my lord.
That, it's allegation is here. We'll call for the CD.
The only thing I will also point out, page
Hmm.
28, one of the similarly situated co-accused person who was also FI name, who is also a neighbor, has already been granted interim protection by this honorable court. At page 28. And I am in custody for 29 days, and in fact, I had surrendered in court.
He has been given interim.
This person, lady, my lord, she has been given interim protection.
You are behind the bars for how many days?
29 days.
Okay, we'll call for a CD, and we'll fix a short date.
It's fixed on 23rd, my lord. So along with that matter.
Okay, 23rd. Heard Mr. S. Nawaz, learned counsel appearing for the accused applicant, also heard Mr. P. Parasa. Decent application
That
under
was
so and
interim,
so.
malat, on
Huh?
67 years old, malat widow, because of that malat interim granted.
Then you write the allegation relates to beating up of a person and they have killing the person. Call for the CD. Let the matter be fixed on
23rd, my lord.
23rd.
Along with AB number 273 of
Along with AB numbers.
I'm deeply.
Give the number.
AB number 273 of
273.
I'm deeply. 54.
In this case, city may be called for me.
Hmm?
City may be called for me. In the entity number.
Okay, heard Mr. A. Martin. Then, A. Martin Ahmed, A. Ahmed, the learned counsel, also heard Mr. So-and-so, this is an application under so-and-so. The case relates to recovery of large quantity of illegal cannabis. Full stop, call for the CD, let the matter be fixed on so-and-so.
27.
27.
Now, this various bail application, you will find FIR at page 15. Page 15. NDPS, although NDPS looks so by a very small quantity of ganja, 1.67, 16 is the relevant, you will find that paragraph. I am.
How much quantity cannabis?
1.671 million from my house. 1.671.
1 point?
671. That is below 100 gram. Up to 100 gram, whether it is small quantity, consumable quantity.
1.67
671
gram.
That is from my
Mr. Parasar,
house, madam.
My lord.
it's a very small quantity.
Of course, that very small quantity, madam.
1.67
So 20.
and 100 grams is a benchmark, right?
Yes.
The 1 gram personal consumption, or what?
Personal consumption, my lord. Secretary is there, my lord. Right?
1.67 gram. Available B can again.
B no, A is there.
B.
Generally, A is attracted, my lord, from my. So my others possession, huge quantity was.
No, what was the other thing? Police recovered 2 numbers of black color big size
Yes,
bag
my
from their possession.
Not
And
my
found-
Position, my lord.
Huh?
Not my position, from the position of other two private,
Matlab,
Moinul Haq and.
Other matlab from the
No,
other.
yeah, I mean, it was recovered from where?
From my house only 1.671.
1 second.
Two numbers of speakers and the cannabis, the recovered black color boxes. 10 kg and 8 kg.
That is not my position, from Moinul Haq and Farid Hussain, from their e-rickshaw. Moinul
Your name is Papu Das.
Appu Dasman. They have said that some quantities in my house, and after search of my house, they have recovered 1.671 gram from Pappu Das.
Okay, we'll see the CD. We'll see the CD. There was, I mean, co-accused, huge quantity recovered. We'll see what is there in the CD. We'll give you a short date and we'll consider. We'll consider. The quantity is very less, but only thing is that let's see what is there, because from the co-accused, huge quantity.
18 kg malad.
Heard Mr. So-and-so, learned counsel appeared for the accused applicant. Also heard Mr. Parasa, this is an application under so-and-so. The case relates to recovery of 1.67 gram. 1.67 gram of ganja from the house of the accused. Call for the CD, let the matter be fixed on
26.
26th. If there is nothing against you, then you have a very good case.
14.
May I plead your lordship? Lordship, the allegation under section 4 of POCSO Act, your lordship, and other section of BNS 137.
Heard Mr. So-and-so, learned counsel appearing for the accused applicant. Also heard Mr. K.K. Parasar, learned APE for the state. This is an application under so-and-so. The allegation relates to sexual assault on the daughter of the sexual assault on the minor daughter of the informant. Full stop. Call for the the informant.
Notice.
Full stop. Let the notice be issued on respond number 2 through the registry as per the prevailing notification issued by the Gauhati High Court. And notice to respondent number 1 dispensed with. Then you write call for the CD. Then let the matter be fixed on.
Short date maybe.
Jagirot, matlab notice has to be served, matlab 2nd of March.
Okay, 2nd of
Notice-
March. Let the
notice has
matter
to
be
be-
later be fixed on 2nd of March.
Yes. May I please, my lord? My lord, pair for peers bail application, my lord. This present petition is no way involved in connection with NDPS Act, my lord. Page 16, this FIR lordship. This present petition not naming the FIR lordship, and no, there is no conscious possession recovered from me lordship. And now lordship, this present petition involved lordship only this offending vehicle use lordship.
Okay, we'll call for the CD. No interim.
There is a lordship.
No interim.
One Ramal is
Heard
honorable
heard
Supreme
Mr.
Court.
So-and-so, the Lord Counsel appearing for the accused applicant. Also heard Mr. Kirti Parasar.
Only lordship 4.4 gram.
So-and-so. This is an application under so-and-so. The allegation relates to
And lordship section 37 of NDPS.
no, this is
Act,
not
this
only, this is 4 cases, more than 4 cases of
No,
cannabis.
no lordship,
It is alleged that 4 cases of suspected cannabis.
no lordship.
You have yourself written,
Yes, lordship.
you page 3,
Page 3,
page
lordship.
3 bottom line,
Bottom.
alleged that
Page three.
4.443
Yes,
kilograms.
lordship. 4.443.
That means what?
That means, this gram lordship, this gram, 4.4 as per mention, this.
You have written,
Page 16,
you have written kilograms.
Kilogram.
not kilograms lordship.
You have mentioned as kilogram.
You have
Oh, yes,
mentioned.
grams, it is kilogram.
Huh?
That is correct, lordship.
Then
It is
why
not
you're,
commercial
then why you're saying grams? 4
Not
grams and
kilogram, yes,
4 kilogram,
4.44
4.5 kilogram
Yes,
almost.
lordship. 4
Then-
kg lordship, 4 kg lordship.
Then
Then
recovery,
lordship, no
the case,
recovered,
the case
conscious
relates,
possession recovered from me lordship.
the case relates to recovery of.
And
4.4
lordship section 37 lordship
4.443.
anti-basic embargo only commercial quantity lordship.
This is, the court is aware of that.
Yes, lordship. And
Four-
this lordship,
four-
interim
4.43,
protection may be allowed lordship. We
4.4
cooperate investigation officer lordship.
4.4
My statement
43
will be
cases
recorded
of
lordship.
suspected cannabis, full stop. From one Activa scooty bearing registration number AS25A1613, allegedly owned by the accused. Scooty is yours, right?
Yes, lordship.
Scooty is
I
yours.
am offending vehicle is mine. lordship.
From this
Arrears are
owned
not
by the
involved, lordship.
accused applicant.
And may
Accused
please
applicant.
lordship.
Call for the CD,
And-
call for the CD, let the matter be fixed on when?
From Sangsari,
Short date,
24,
He's seeking for AB short date,
24.
24. See, first of all, you, when you submitted, you said 4 grams.
Yes, not.
And
very
4
sorry.
grams and
Not-
then you,
Yes,
I mean, this
four.
is your case, NDPS case, and you are not prepared. And what is the quantity you are not aware of? And you are now pressing that give me bail, give me bail, give me bail. And the quantity was recovered from your scooter. Next
That is
matter, next
correct.
matter.
Not possession from me, lordship.
Next
And
matter, next
honorable
matter.
Supreme Court lordship, this judgment.
Next matter,
lordship-
next matter. You come and argue on the next date.
24.
May I please, your lordship?
Yes.
This is an application for under section 482. Your lordship will kindly come to the FIR
FIR page,
page, your lordship, page 12, your lordship. It was registered under your lordship 126-2. 10832. Yeah.
Yes, Mr. Bhattakur, it's a serious allegation.
No, your lordship will kindly come to page 20. This is an agreement. Now, your lordship, the Honorable Apex Court is very clear when abatement of suicide will come, your lordship. Page 20. This is an agreement, your lordship. He signed it. He took 2,50,000 from me. I demanded back the money. Anyone will demand the money back, your lordship. If someone committed suicide for that,
No, correct, I understand that.
now,
I
your
understand
lordship
that.
will kindly see that therefore, your lordship, for abatement of suicide, your lordship, there will to be a mens rea, your lordship. And that mens rea, on the face of the agreement is not there, your lordship. And I have not even took interest from them, your lordship.
Okay.
Your lordship will
heard
kindly
Mr.
see this judgment.
We'll give you interim protection.
Lordship.
I heard Mr. S. Bhattakur, the learned counsel appearing for the accused applicant, also heard Mr. Mr. K.K. Parasad, learned APP for the state. This is an application so and so. The allegation as contained in the FIR is entirely that the informant's brother took a loan of rupees. How much? How much was the loan amount?
2,50,000, your
Huh?
lordship. 2,50,000.
2,50,000. 2,50,000 from Sumit Das, na?
Lordship,
From one person, from
the petitioner. Your
from the accused applicant, namely Sumit Das. And it was alleged that since the brother of the informant was unable to return the money in spite of repeated requests from by the accused applicant, the brother of the informant, namely Sri Mandip Bora, after consuming some insecticides. Is it insecticides or what?
Lordship, she says in.
Poisonous insecticides used in the tea garden, committed suicide, full stop. That FIR date you have given, 19/1/2026, huh? 19/1, FIR 19/1/2026. Then you write, the learned counsel, as Bhattakur learned counsel appearing to the accused applicant submits that in fact there was an agreement between the deceased person with the accused applicant for the loan amount, and the same was supposed to be given back, supposed to be returned to the accused applicant in time. However, since the money was not returned by the deceased person, the accused applicant was requesting him couple of times about the money. He further submits that the action of demanding or requesting money which has been taken by the deceased is not an offense, and that certainly cannot be termed as abetting suicide of the deceased person. Full stop. In view of the opposite, he submits that at this stage, at least interim protection should be granted for him, and he will fully cooperate with the investigation in the instant case. Full stop. The learned APP,
Madam, 9th of March.
you have any objection to this? Learned APP, learned APP, the learned APP opposes to the granting of interim protection at this stage. Full stop. After hearing the submission of the counsel appearing for the respective parties, as well as going through the materials brought on record, this court is of the considered opinion that interim protection should be granted to the accused applicant at this stage. Accordingly, it is directed in the event of the arrest of the accused applicant by the investigating officer in connection with Dergaon Police Station case number 17/2026, he shall be released on bail on furnishing of a bail bond of rupees 20,000 with a surety of like nature to the satisfaction of the arresting authority, subject to the following conditions. Number one, that the accused applicant shall appear before the investigating authority within a period of 10 days from passing of this order. Number two, the accused applicant shall fully cooperate with the investigation and present himself as and when called for. Number three, the accused applicant shall not try to tamper or hamper with the evidence involved in the instant case. in view of let the matter be listed on
9th of March.
9th of March.
Did go.
55. Made page to create arrest bail application lordship. The FIR is at page 40. 42 the additional affidavit.
What is that additional affidavit?
The FIR lordship, it was inadvertently lordship,
Hmm?
allowed me to. Day before yesterday, the matter was fixed lordship.
Hmm.
FIR was inadvertently not annexed in the content.
Ah,
of the
yes,
FIR,
yes, yes.
lordship.
So this is the FIR word.
Yes, lordship. The allegation is that lordship, during NACA checking, one LP truck was intercepted
Hmm.
and on the suspicion of.
Let us go through the FIR.
Yes. 42.
Yes. Yes.
But I am not named in the FIR.
Hmm.
Police visited my house and informed my family members that my.
The
uh,
vehicle belongs to you.
No, lordship, the driver, manager, transporter, owner, all have been granted bail, lordship.
Hmm.
The investigation has been substantially progressed.
Hmm.
Co-accused, all the co-accused. have
How
been-
you have been implicated?
Lordship, my implication, lordship, I was involved in the loading of the coal, lordship, at the point of time. Lordship, police
What- what-
visited my house.
What do you do? You were a loader. I
Yes,
mean,
Lord.
huh?
Yes, Lord.
You were a loading agent or what?
Loading, I was involved in the loading, yes, sir. Loading agent.
लहान गुन्ह्याबद्दल नाही. बिल पाहिजे नाही.
Also, I have also annexed the forwardings of the 3 accused persons who have been granted bail. On 3 of the forwarding reports, my name has not been mentioned anywhere, lordship.
Let him go.
Others will.
Heard, Mr.
H. Agarwal.
Mr. Agarwal, the learned counsel appearing for the accused applicant also heard Mr. K.K. Parasar, the learned APP for the state. This is an application. This is an application under so and so. An FIR. An FIR dated 16/10/2025 was lodged by one Sri Pranjal Kumar Gogoi, the senior geologist, director of geology and mining Assam, before the officer in charge Margate Police Station, alleging inter alia that on 14/10/2025 during Naka checking near Dihing Bridge within the jurisdiction of the said police station, an LP truck bearing registration number AS01 SC stroke -5036 allegedly carrying coal was intercepted on suspicion of illegal transportation. It was alleged that the vehicle laden with the coal and on questioning, they could not produce any document. Any document such as tax invoice, challan or e-way bill before at the time of inception. it was also alleged that the transportation of coal was being done without paying the e-bill, which constitutes the violation of Rule 6 of Assam Minerals in bracket regulation and dealers in bracket complete rules 2020, as well as section 4(1) in bracket 1A of the Mines and Minerals Development Regulation of 1957, Development and Regulation to bracket. After receipt of the FIR, next paragraph, after receipt of the FIR, the Margarita Police Station case number 126 of 2025 under section 303 in bracket 2/3 in bracket 5 of BNSS, BNSS read BNS 2023 read with section 21. It is a legal 1957. Section 21 of the Mines and Minerals in bracket regulation 1957 and section 3 of Prevention of Damage to Public Property Act 1984 was registered. The learned counsel appearing for the accused applicant submits that the accused applicant is no way linked to any alleged alleged offense that has been alleged to have been committed in the FIR. He submits that the accused applicant is merely a loader in the truck, and he is no way involved in the aforesaid allegation, aforesaid offense as alleged in the FIR. He further submits that that who are those other person?
One is the driver, one is the manager of the transporter, one is the transporter, and one is the owner of the vehicle.
Okay, and the main accused, that is the manager of the agency, manager of the manager of the transport company, driver and owner of the vehicle who have been arrested by the police have already been granted bail. Full stop. He submits that since the police is visiting the house of the accused applicant and asking about him, he is apprehending arrest, and therefore the instant bail application has been filed. Full stop. In view of the he submits that the accused applicant shall fully cooperate with the investigation. Therefore, he should be allowed to go on pre-arrest bail at this stage. Full stop. The learned APP, Mr. K.K. Parasa, on the other hand, opposes the opposes granting of bail at this stage. Full stop. This court has gone through the materials brought before this court, as well as heard the submissions made by the learned counsel appearing for the parties, and on consideration of the facts in entirety, and taking into account the facts that the main accused in the instant case accused have already been granted bail by which court, who has given
The
bail?
landed SDGM, owner is.
Already granted bail. This court is of the considered opinion that the prayer in the instant AB application should be allowed. Accordingly, it is directed that in the event of the arrest of the accused applicant, by the investigating authority in connection with the Margarita PS case number 126 of 2025, he shall be released on furnishing of bail bond of ₹20,000 with a security of like nature to the satisfaction of the arresting authority, subject to the following conditions. Number one, that that accused applicant shall appear before the investigating authority within a period of 10 days. And number two, that accused applicant shall make himself available as and when called for by the investigating authority. Number three, accused applicant shall not tamper or hamper with the evidence involved in the instant case. Next, but I write, in view of the aforesaid direction, the instant bail application is disposed of as allowed. AV application is disposed of as allowed. We are disposing it of. Lord Mr. Anna Hassan.
Wait, please, Your Lordship.
Lord-
We are
Learned-
seeking Lordship default bail, Lordship.
Default bill.
Default bail.
Okay. Where? How?
Default bail,
Yeah,
Lordship.
you are in jail for how many days?
Lordship till petition number 114 days.
How many petitioners are? Two.
Two petitions. Petition number 1 is 114 days.
UAP আছে
And petitioner number 2, Lordship, 113 days,
Petitioner number 1 for
114 days, 114.
114 days.
And petitioner number 2, 113 days,
Petitioner number 213 days.
13 days, Lordship. After expiry of
Is
90,
intermediate quantity.
no, Lordship, UAPA.
Hmm?
UAPA, Unlawful Activities Prevention.
UAP is 16.
Oh.
UAP is 16 and 17.
We Lordship filed the default bail petition before the London court below on after expiry of 90 days.
Hmm.
So that has been rejected, considering the ground that IO has submitted a prayer for extension of Lordship in time for investigation, Lordship. IO has submitted, not the PP, Lordship. Then Lordship, may kindly see our Lordship order, order rejecting bail, Lordship. That Lordship will find at page number 38.
38.
38. 38, Lordship, may kindly see third para. It order dated 21/1/2026. Third para, seen the petition number 181/2020 filed by today on behalf of the accused by Malabya Bora. Petition number 1, Lordship, hearing with a prayer for bail. Then Lordship, there are other accused person, Lordship. Then para 6 is the Lordship facts of the. No, Lordship, this is the important. The learned counsel for the accused submitted that the accused persons, namely Malabya Bora, Maina, Elias, and Badal Gwala, were arrested on 22/10/2025 and have completed 91 days in detention. And the statutory period of 90 days expired on 21/2026. But till that, no charge sheet final report has been filed by the IO. Hence, the above named accused persons are entitled to a default bail. Furthermore, the accused Bitul Borua was arrested on 31/10. That is a defined Lordship, accused Lordship. Then Lordship, may kindly see paragraph 7, Lordship. Next page.
No, I have filed petition on the 16 one.
But it can be filed, it cannot be filed by IO.
That is the.
That has to be filed by PP.
With a resume.
PP has to specifically file an application.
Then Lordship, may kindly see para 7. Para 7, Lordship, may kindly see.
No, no, I mean that I already say, what was the provision?
Provision, Lordship, may kindly see 43.
43 of,
APA, Lordship.
huh?
Unlawful Activities Prevention.
Yes, ELPA. That is very specific, Mr.
Specific.
Mr. Parasar.
No, my lord, yes.
43D to
But-
B. 43D to B.
One second.
My lord, yes, application has to be submitted to the PP. PP has to apply mine.
PP, only PP is the authorized person statutorily. IO cannot do anything. IO can write, IO have to give his note, reasons why it's required to be extended. Then PP will file an application. 43?
43D, subsection 2, then B, small b. May I read, Lordship?
Yes.
After the proviso, the following proviso.
No, but 43?
43D,
D.
D,
D for Delhi.
D for Delhi, capital D.
Capital B.
Then Lordship, may kindly say subsection 2.
Yes.
Then Lordship, section 167 of the code, the CRPC,
Mm.
shall apply in relation to a case involving an offense punishable under this act, subject to the modification that in subsection 2, the reference to 15 days, 90 days, and 60 days, wherever they occur, shall be constituted as a reference to 30 days, 90 days, and 90 days respectively. And then subclause Lordship B. After the proviso, the following proviso shall be inserted, namely, provided further that if it is not possible to complete the investigation within the safe period of 90 days, the court may, if it is satisfied with the report of the public prosecutor, indicating the progress of the investigation and the specific reasons for the detention of the accused beyond the safe period of 90 days, extend the safe period up to 180 days. This is Lordship important, Lordship. The report-
There was an order passed by this court also. You have the order? No.
I have the some citation of Supreme Court and on
No,
this
This
honorable
court
court
has
also.
also passed one order.
One Lordship Samsun Noor.
Hmm?
One judgment I found Samsun Noor of this honorable High Court, Lordship.
This bench has also passed one order.
Oh, that I could.
Hmm.
Here, Lordship, the extension was allowed only on the petition filed by the IO. That is reflected, Lordship, in the order itself.
So Parasar, it's a statutory violation of statutory provision.
My lord, yes, also.
You give me
regarding-
the case laws, Supreme Court
Well,
case laws, which are there? No, it is very specific. I mean,
Yes, PP was heard, but
and
that-
Supreme
that-
Court
that-
has,
that- that
Supreme Court has laid the
Yes.
guidelines also.
Yes, my lord.
How it has to be done.
Application is not before us, my lord.
Hmm?
But the order it is reflected, my lord.
Hmm.
Application is not before us. Who has signed, my lord? PP?
No, it has been stated IO has signed, filed it.
That application I have annexed, Lordship. Lordship, IO has simply pressed for the same.
No reason, no reason.
No reason, Lordship, endorse the petition of the IO. I have submitted the also.
This is page 46, huh?
This is Lordship.
Page
Lordship has-
46.
Lordship has got that.
And that application is page 46.
Page 46.
Yes, page 46.
Two application I have submitted, 44 and 46.
See, Mr. Parasar, this person who has written it, he's an APS, but he's not aware of any of the procedural laws. The SP.
Yes, my lord. Yes.
Yes, I mean, this court has passed an order, I mean, like referring to this case. This is very clear in this case. Para.
Para 22 and 23, Lordship. Twenty-three is important, Lordship. May I read 23, Lordship?
The public prosecutor has to
Yes.
independently apply his mind
Yes, yes.
after getting the report or application, whatever, from the IO.
But perhaps.
Then PP will write.
Yes, yes, my lord, but perhaps, my lord, may kindly see this petition on page 26, page 46
Hmm,
is dated, my lord, 21/1/2026.
hmm.
Here in page 47 also, my lord, 21/1/2026. My lord, now in the order, page 39,
Hmm.
peruse the record, it is seen from the record that the IO filed a petition on 16/1/26.
That
Hmm.
also I have annexed, 16, page 44.
That he is annexed,
Two
na?
application the IO has filed, Lordship.
So the problem is that IO has directly filed it to
Pro
the,
PI, Pro PI court.
huh?
Pro PI office, he has filed to the court. Lordship.
Through PI office, directly filed to the court.
And Lordship may kindly see the role of the IO, role of the PP, Lordship. May kindly see page 13 for a moment.
He said like, regarding prior actions of the,
Yes, he has
and-
pressed for the same. And Lordship, then and also Lordship may kindly see, Lordship, page 42, para 4 for a moment, Lordship.
para,
Para 4, page 42. This is order dated 22/1/2026, Lordship,
hmm,
where the prayer for with regard to petition number 2 was rejected. Para 4, Lordship,
hmm.
Learned PP has submitted that he endorsed the petition filed by the IO on 16/1/2026, that is before completion of statutory period of detention of the accused for extension of time for completing the investigation and for filing charges, but admitted that he has not filed any separate report. In that regard, and for that reason, the accused cannot be granted default bail, as the petition was filed by the IO before completion of statutory period of detention of 90 days. IO did not file any report, Lordship, only simply endorsed the petition filed by the IO, Lordship. The PPs did not file any report, Lordship. But the Honorable Supreme Court has said that PP is a independent, Lordship, authority. In one judgment, I have also submitted lordship of the Honorable High Court of Jammu and Kashmir and Ladakh.
But this, Mr. Parasar, that learned special judge Tinsukia has, discussed the case of Hitendra Vishnu Thakur.
Yes, sir, my lord.
After that, he has come to a conclusion also that this was not filed by the PP, it has been filed by the IO. Then he says,
Before 90 days I was filed.
no. Then he says, come to page 43.
Yes, ma'am.
It's quite amazing. While forwarding so and so, IO for so and so, but for that reason, the accused cannot be granted default bail. The court, after perusal of the materials in CD and considering the entire facts of the case, rejected the bail of the persons earlier, Bitul Borwa so and so so and so. This is totally against, the ratio laid down by Hitendra Vishnu Thakur case. And it is a statutory provision.
DSP like officer is doing malad such type of activities. Yesterday that case malad. Now.
And they are not aware, these provisions at all. Because directly writing to the special judge. So we'll have to allow him. So we'll do one thing, we'll pass the order in the chamber. It will take some time because to refer to these cases and.
Other judgment, lordship may kindly see that High Court of Jammu and
No,
Kashmir.
done.
Yes.
Mr. Hassan, we
Lordship.
have already come to some kind of thing. Now don't take the court's time
Lordship.
unless. You'll pass the order in the chamber.
Much obliged.
Chamber pass করুন, এখন রাখি দেবো না। Bail hearing, motion কি?
May it please your lordship. We have taken steps on respondent number 2, my lord. And it seems that it is awaited. Office note dated 31, my lord.
So you have taken fresh steps, when?
On 30th, my lord. 30th.
31.
So for a second time, we have taken the steps. And it is not too far also, lots of Pragjyotispur PS.
Mr. Borwa, you'll have to find out. Lot of notices are not being served.
My lord.
And he's almost behind the bar for almost a year, lots of 19-3. It will be complete 1 year.
Okay, we'll put a short date,
That's-
I mean, then if the next date doesn't appear, then we'll, because 31 you have taken, no?
Yes.
But it's all 31 of, I mean, 10, 15 days.
Mm.
We heard Mr. D. Das, the learned counsel appearing for the accused applicant. Also heard Mr. Ajay Borwa, the learned APP for the state. Office note dated 31/2026 reveals that notice was issued to respondent number 2 through APP on the same date, that is 31/2026. However, report of receipt of notice is yet to be received. Let the matter be fixed on 24th,
25th, my lord.
25th. 25th.
I'm obliged.
Made please, your lordship. Well, it's a charge sheeted case, my lord, under POCSO, my lord. Well, I am not on the merit of the case, my lord. I am only on the point, my lord, that section 48 notice is not complied with.
48.
48, my lord. Although there was a WT message sent to the police station, my lord, but it was not served upon the family members or the friend or relatives of the accused, my lord. I have gone through the record, my lord, I have not found it.
Order to sell. এটা একটা অর্ডার টুসলের জন্য আবার অ্যানবডি সার্ভিস খুব করে এটা রাইট পারসন দরকার হওয়ার পরে মেন্টালি এই কি একই কেস এটা তাহলে সেটার উপর সব এটা অর্ডার
In addition to that, section 48, my lord, the arrest memo is not attested by any witness.
From the page number 17, my lord, annexer 2.
Hmm.
My lord,
Forwarding.
for 47 and 48 notice, my lord, it was issued through WT message, my lord. 47 notice was received by him, my lord. But as far as 48 is concerned, my lord, it was forwarded through WT message.
47 doesn't contain the grounds of arrest. There is not a single ground of arrest. Nothing. You see 47? Ground of arrest is not there. You are a FIR named person.
Yes, this is FIR.
The victim girl furnished sufficient evidence. Then arrest memo, grounds of arrest totally blank,
Not attested.
not attested by. W2 message to OC, whereas this person is from Assam only.
No, he's from, my lord, Fakiraganj, my
Yeah,
lord.
Fakiraganj ka hai.
There are sufficient loopholes also. If your lordship sees the forwarding, my lord, it is 8th of September 2025. And the FIR your lordship will see, my lord, it is, my lord, 12/9, my lord.
Yes, Mr. Borua.
Record, I'll go by the record, my lord. Because he is taking this ground specifically.
Heard Mr. N.J. Datta, the learned counsel appearing for the accused applicant. Also heard Mr. R.J. Borua, the learned APP for the state. This is an application you write, huh? The allegation as alleged in the FIR dated 12/9/2025, inter alia is that on 7/9/2025 at 7 p.m., the informant's minor niece, aged about 13 years, 2 months. 13 years, 2 months. See your prosecution, the prosecution story. But 13 years, 2 months, while coming home, the accused applicant allegedly induced her to come with him and thereby taking her to a bamboo field, committed rape on her. It was also alleged that on 8/9/2025 also, the accused applicant had committed rape on her. Full stop. Next pair. On receipt of the FIR, the police registered the Bilasipara PS case number 295/2025 under the aforementioned sections. Full stop. The accused applicant was arrested on, when was he arrested?
My lord, on
8/9.
8/9.
8/9/2025 itself, and since then he is behind the bars. After investigation, the police filed the charge sheet number 281 dated 23/10/2025 before the special judge Bilasipara, Dhubri, Assam. What is the stage of trial exactly?
My lord,
I think
charge is yet, charge frame, my lord,
charge framed.
Charge frame, my lord.
Charge frame, I think some victims are, and some of the people are examined also.
No, the victim yet to examine, my lord.
Hmm. Be charged against the accused person with 4 hits was framed on 5/2/2026.
And the next date is fixed on 18/2, my lord.
However, till date, none of the witnesses named in the charge sheet has been examined. Full stop. Mr. N.J. Dutta, the learned counsel, appearing for the accused applicant, submits that rather than the merit, at this stage, he would like to submit before this court that the mandatory provisions of Section 36 of BNSS as well as Section 48
48.
of BNSS are not complied with while arresting the accused applicant, which makes the arrest itself illegal, and on that ground alone, the accused applicant should be granted bail at this stage. He submits that the Honorable Apex Court in pattern of cases including this High Court, have held that in the event of any violation of the mandates of the statutory provisions as prescribed under the BNSS under section 36 and section 48 of the BNSS 2023, the arrested person gets an unfettered right to get unfettered right to get bail. Full stop. In this connection, he has referred to the case of DK Basu versus State of West Bengal, reported in 1997 1 SCC 416, as well as State of Karnataka versus Sridarsan, etc., reported in 2025 SCC online SC 1702. Full stop. I'll just come back and dictate them. Just 5 minutes.
Fine.
Last line. DK Basu. On the other hand, Mr. R.J. Borwa, the learned APP, appearing for the state, submits that that the accused applicant is involved in a heinous crime of rape of a minor girl, and there are sufficient prima facie materials against the involvement against the accused applicant of his involvement in the instant case. He further submits that since he submits that section 36 and section section 36 and section 48 notices were not properly worded, the same does not prejudice the accused applicant in the instant case. Therefore, he opposes the prayer of bail of the accused applicant in the instant case. This court has heard the submissions made by the learned counsel appearing for the respective parties, has also perused the trial court record that has been placed before this court. Did you quote para 8 from here? Para 8. Then you write, this court has gone through the notice under section 36 of BNSS, which is available in the trial court record. The same does not contain any grounds of his arrest, as well as no signature of any of his relative or any respectable person of the locality was taken when the arrest was made. As far as section 47 notice is concerned, this court is of the is a concern, though there are certain grounds have been stated in the considered opinion of this court, the grounds are not sufficiently worded. Full stop. Next, you write, as far as section 48 notice is concerned, this court found one WT message which was sent to the officer in charge of Fakirganj PS district, South Salmara, whereby the OC was requested to inform the family member of the accused applicant. From the above notices, it is from the contents of the above notices, it is apparent that the mandates of the aforesaid sections of aforesaid section, that is section 36, section 47, and section 48 of BNSS are not complied with. Rather, there are severe violation of those conditions by the arresting authority while arresting the accused applicant. Full stop. Taking into account the settled principle of law laid down by the apex court in the aforementioned cases of D.K. Basu Supra, Vihan Kumar Supra, and Prabir Purkaist versus state in bracket NCT of Delhi, reported in 2024, 8 SCC 254. This court is of the considered view that while arresting the accused applicant, the mandates of settled law have not been complied with, and therefore it merits, and therefore the instant application merits the accused applicant to be released on bail. Full stop. In view of the aforesaid finding, the accused applicant, namely Sahidul Islam, alias Sohidul Islam, SHOHIDUL, Sohidul Islam, is directed to be released on bail forthwith on furnishing of a bail bond of rupees 50,000 with a security of like nature to the satisfaction of the Special Judge POCSO, Bilasipara, subject to the following conditions: that the accused applicant shall appear before the trial court as and when required. Next, the accused applicant shall not try to get in touch with the victim girl or her family members till the family members in whatsoever manner till the completion of the trial. Full stop. Next, in view of the aforesaid direction, the instant bail application is disposed of as allowed. In between, you write, heard Mr. S. Das, who appeared as a amicus curiae in the instant case. What is your submission?
Non-compliance of 48.
Okay. He also submitted that there was no compliance of 36, 37, and 38 in the instant case of PNSS in the instant case while arresting the accused applicant.
I'm obliged. Can I take one indulgence, item number 50, my lord? The diary is not there, my lord. Can it be next week?
Okay, item number 50.
50, any date next
Case
week?
diary is not received in the instant matter. Let the matter be listed on
20, my lord.
5.
23rd.
20. I'm obliged, my lord.
19.
It is corporate.
Case that is not received, my lord, item number 19.
Case that in the instant case is yet to be received, let the matter be fixed on
140 days behind the my lordship.
Hmm?
140 days behind.
40 days.
140 days.
Okay, we'll list it on 23rd. 23rd.
Not February, Lord. Obliged.
May it please, my lord. NDPS matter, my lord.
Hmm.
My lord, 47 notice was served to us on a delayed basis, my lord. On 17/6/25, my lord, we were caught hold by the police, my lord. On 18/6, my lord, we were given the 47 notice. If my lord kindly has the FIR at page 16, my lord, 16, if I may read my.
1 second.
Yes, please.
You were arrested on?
My lord, on 18, I was given the 47 notice, my lord.
No, when you were arrested?
17, my lord.
17 what time?
17 around 2 p.m. Actually, my lord, there was a
17?
around 2 p.m.
17 which date? 17?
17/6/25, my lord.
17/6/25.
Yes, my.
I mean, you have been apprehended.
Yes, my lord. There was an accident, my lord, between our vehicle and one rickshaw, my lord.
Hmm.
And thereafter, my lord, I was taken to one of us was taken to the hospital. One of us got injured also.
Hmm.
Then, my lord, we were getting treatment and everything
Hmm.
from 2 p.m. till 8. The entire day we were with the police only. One of us with the police also. Next day, my lord, at page 31, my lord would find the 47.
When were you produced before the court?
18/6.
18,
Next day.
18/6 what time?
18/6, my lord. Forwarding, my lord. Page 42, my lord, would have.
18/6 what time?
Yes, my lord, I'm coming to it. My lord, produced before the court that time. Well, it is written 18/6 I was produced, my lord. Time is not specific. Otherwise, my lord, section 47 notice also I got in the next day, my. That is my case, man. My lord, page 31 would also show that time was also not mentioned, my lord. Regarding my arrest, my lord. Article 22(1) has been violated, my lord. Grounds of arrest should be given as soon as possible.
Yes, I mean, your submission is that?
My lord, my humble submission is that on 17/6/2025, we were apprehended, my lord, at 2 p.m., my lord. Then next day, my lord, 18/6, my lord.
You have been arrested only on 18/6, 10:30 a.m.
Yes, my lord, but I was with them only, my lord, because if my lord peruses the FIR, my
He
lord.
got
then
injured, so he was taken to hospital.
One of us were taken to the PO, my lord. One was taken to the Joklabanda hospital and one was taken to the PO. And eventually both of us were taken to the PO. Now, my lord, we are deemed to be arrested because we were in the custody of the police. They could have given us, they could have served us the 47 notice. I am not on the 48 notice, my
The
lord.
47 notice was given to you.
Next day. Next day. The purpose is
The
defeated
47 has to be given to you when?
as early as possible, as per the language of Article 22. my
No,
lord.
no, as per this, the latest case,
Rajesh, my lord, Rajesh Mihir Shah also says, my lord.
Rajbisa says that like latest by 2 hours before the arrest,
Before production, my lord.
before production.
My lord,
So before production, I mean, how do you say that like you have not been given?
my lord, may I kindly refer to Rajesh Mihir Shah once more?
No, no, I have read it.
Yes,
Is there any dispute about this? That latest by 2 hours,
my lord, that.
latest by 2 hours, as early as possible. That is correct. As early as possible, but they said the benchmark that 2 hours prior to the production.
Yes, my lord, that is there.
Correct. So now you have been produced before the magistrate,
Yes.
and you have been given the arrest memo. I don't find any infirmity in the arrest memo because signature was taken, then grounds were given, everything has been done.
Well, everything is there, but my lord, it has been given in a delayed form, my
No,
lord,
not
after
delayed
1 day.
form. How can you say delayed form?
And apart from that, my lord, I have one more contention, my lord, in my case. The search and seizure which was done without my presence, my lord. Because if my lord has already gone through the record, there was an accident, my lord.
Yes.
After the accident.
One person was there.
No, my lord.
One person was there.
No, my, may I kindly, my lord, I'll refer to the pages, my lord. I've appended everything in my petition. Lordship would have page 24 for a moment, lordship.
24.
24, lordship, of my petition, lordship, for a
Okay.
moment.
Hmm.
24, my lord, would have the date and time of seizure, lordship.
24.
24, search and seizure list, lordship.
Yes, yes.
On 17/6/25, at about 3:30 p.m., my lord would kindly appreciate the fact that accident took place around 2 p.m. I was taken to the Jokhalabanda hospital. Accident took place at Hatbor Sariali, Jorhat. Thereafter, I was immediately taken to Jokhalabanda, that hospital. Thereafter, my lord, if at 2 p.m. I was taken there, how can the search and seizure be conducted?
Now, from where you are saying that you have been taken at 2 p.m.?
My lord, from the FIR, from the forwarding, everywhere it is written. Page 16, my lord.
Page 16.
Page 20 is the FIR.
Yes.
Written. May I kindly read, lordship?
Yes.
With reference to the subject cited above, I, the below undersigned, have the honor to report you that today on 17/6/25, an information was received from Sri Jadhav Bora, so and so, stating that a road traffic accident, RTA, had occurred at Hatbor Sariali, that is Jorhat, wherein a scooty bearing number so and so collided with the rear side of an e-rickshaw. As a result of the collision, both the driver and the pillion rider of the scooty sustained injuries, that is us. Accordingly, a GD entry was made at Jokhalabandha PS by GDE number 10 dated 17/6/25. I so and so along with so and other staff proceeded to the place of occurrence. Upon arrival at the PO, it was found that the one of the injured persons had already been shifted to Koliabor Subdivisional Civil Hospital, Jokhalabandha, for medical treatment. And the other injured person was at the PO along with the scooty. Damaged scooty was found lying on the roadside. During examination of the vehicle, local residents pointed out a black polythene bag hidden in the lower part of the scooty. Upon preliminary verification, it raised reasonable suspicion of contraband narcotic substances. Matter was immediately communicated to the co-district superintendent of police, Koliabor, and other senior officers, and after some time, CDSP Koliabor along with OC Koliabor arrived at PO. The injured individual, after receiving preliminary medical treatment, was also brought to the PO for necessary follow-up action. My lord, At least one of us were not there, my lord. This clearly shows.
No, no,
No, my lord would kindly appreciate.
no, 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 no.
My lord, we were not there during this.
No, no, you were there, you were there. Yeah, one person was definitely there. Other person also, he was brought in later on.
My lord, but signatures were taken at 3:30. My
No,
lord, as
no.
per section.
That doesn't visit the arrest.
My
That
lord,
doesn't
section
visit the
50
arrest.
of the NDPS, my lord. May I
That
kindly
does-
refer to
that-
once, my lord. Section 50. What
Yes.
lordship would kindly have it once, my lord.
Yes, yes.
Just take 1 minute of the honorable.
Yes, yes, yeah, sure.
50 lordship has once.
Hmm.
If
Section-
I may read lordship.
Yes,
Yes, lordship.
please.
Conditions under which search of person shall be conducted.
It's a person, bodily search.
Yes, my lord, but my lord, here also, my lord, I'll just take 1 minute. My lord. When any officer duly authorized under section 42 is about to search any officer under the provisions of section 41 and 42 or 43, he shall, if such person so requires, take such person without.
This is search on person. Search on person. When something was lying there, it was, it was pointed out to the police.
Yes.
Don't you think that police will try to see what is there, what is not
Yes,
there?
my lord, they will
Then,
definitely see. But
and then the one person, one of the accused person was there. The other person was also, after preliminary medical treatment, he was brought to the PO. Then where is the case of,
that
not being present?
That one signature I have problem with. My lord,
No, no,
page
no, no.
25, my lord. How did, if I was in the, if I was taking treatment in the hospital, my lord, how is my signature there, my lord?
You were brought in later on.
Then, my lord, later, if my lord,
Mr. Sharma, don't bring in those things like, when I will sign those factual things. This court is not going to see. In trial, you argue all those things.
my lord,
But like you saw something which is the blatant violation of the procedure. You saw me something which has been not complied with. This court is, ready to hear you, ready to see all the documents. The court has already seen the documents. In this section 46, section 36 BNSS,
yes,
47, 48 complied with. There is
Completely.
no violation of that.
I am not on that.
Correct. So all this, that nothing has been done. You are saying now that you are submitting that section 47 notice was not given you in time.
Yes, my
That also there is no material showing that like it was not given it to you. It was given it to you when you were produced before the court.
My lord,
So
the provision says otherwise. And my lord, may I kindly refer to Mihir Shah for a moment, my lord? May I
now,
kindly-
Mihisa, we have read it many times.
My lord, just one paragraph, my lord.
Yes,
Just
yes.
one paragraph would say.
Yes, yes. For your satisfaction, you read it.
Yes. My lord, para 52.
You have a copy
Yes,
of that?
yes, my lord.
Para 52.
Yes, my lord, I flag
Yes.
marked the portion. my lord.
Yes, yes.
I'll read, my lord.
Mm.
We thus hold that in cases where the police are already in possession of documentary material furnishing a cogent basis for the arrest, the written grounds of arrest must be furnished to the arrestee on his arrest. However, in the exceptional circumstances such as offences against body or property committed in flagrante delictio, that is when someone is caught red-handed, where informing the ground of arrest in writing on arrest is rendered impractical, it shall be sufficient for the police officer or the other person making the arrest to orally convey the same to the person at the time of arrest. That is what I'm on, my lord. 17:6, my lord, I was with them, my lord. My lord, here I was not caught red-handed, my lord. I was not doing the act and they caught me. There was a collision of my vehicle and the rickshaw, my lord.
Okay, read on.
Yes, my lord. That is my relevant portion. After that, 2 hours come.
What is the relevant portion?
That paragraph only, my lord.
What orally you have to be told?
Yes, my lord.
Huh?
No, my lord, my lord, that this paragraph says, my lord, this word, my lord, flagrante delictio,
No,
which means caught
correct.
red-handed.
Correct.
My lord, we were not caught red-handed.
If you are caught red-handed.
If we were caught red-handed, then that written 47.
No, what is your submission? If you are caught red-handed, then what?
I'm caught red-handed in these kind of offenses, these property offenses.
No,
body
you tell me now what, if you are
My
caught
lord-
red-handed, then what is to be done?
Then, my lord, oral information is also enough. 47 is not amended.
Okay, then 47 is mandatory only when, somebody is not caught red-handed.
No, my lord, that I'm not on that.
Then-
I'm saying, my lord, we were not fleeing away. My lord, I am saying, my
No, no,
husband submitted-
the thing is that, see, we have seen the records.
Yes,
47, 48 notice have been given to you. Arrest memo was prepared, given to you in time, and you have been produced before the court within 24 hours of arrest. Then what is your case?
47 notice was given after considerable delay, my lord.
What
After-
considerable? How can you say that?
No, because from 17/6 I was.
No, no, 47 notice was given to you or in a delayed time. How can you say that? Is there any material to say that?
Yes, my lord,
Where?
the 47 notice itself, because 17/6 I was.
No, no, no. Please don't argue for the sake of arguing. Heard Mr. R. Sharma, the learned counsel, appearing for the accused applicant. Also heard Mr. R.J. Borwa, the learned APP for the state. This is an application under so and so. An FIR was lodged on 17/6/2025, wherein it lodged by one Ritumoni Deka of Jaklavanda PS before the officer in charge of Jaklavanda PS, alleging inter alia that on 17/6/2025, an information was received about a road accident occurred at Hatibor Sariali, wherein a scooty collided with the rear side of an e-rickshaw. That because that due to the collision, the rider and pillion rider, both the riders of the scooty got sustained some injuries. That on arrival on the PO, it was found that one of the accused person was already shifted to Koliabor Subdivisional Civil Hospital, Jaklavanda for preliminary medical treatment, and the other person was at the place of occurrence along with the scooty. The damaged scooty was found lying on the roadside, and during examination, when pointed out about a black polythene bag hidden in the lower part of the scooty, on examination, it was found that the bag contained 969 grams with soap cases and polythene pouch, in bracket you write, with soap cases and polythene pouch, and 289 grams in bracket net weight of suspected heroin without soap cases. 969 grams you have written, and then you write the suspected heroin, okay, were recovered. That the injured individual, after receiving preliminary medical treatment, after receipt of the preliminary medical treatment, was brought to the place of occurrence for necessary follow-up accident. That a total of 25 soap cases were recovered from the aforesaid polythene bag. On receipt of the aforesaid FIR, Jakalabanda PS case number 65/2025. Under section 21 in bracket C stroke 29 of NDPS Act 1985 was registered against the accused applicants. No, full stop. The learned, Mr. R. Sarma, the learned counsel appearing for the accused applicant submits that though the notice under section 47 and 48 were served on the accused applicants as well as their family members, the same were not submitted in time. He submits that though the accused applicants were in fact arrested on
625.
17/6/2025, they have been shown arrested on 18/6/2025, and the notice under section 47, which is mandatory to be given to the accused applicants before their protection before the magistrate was not given. Full stop. He submits that the notice was served on the accused applicants in a delayed manner, which vitiates the whole process of the arrest, being in violation of the mandatory provisions under the BNSS 2023. Full stop. The learned APP, on the other hand, the learned APP, Mr. R.J. Borwa, the learned APP submits that there is no violation of any statutory provisions in the instant case while arresting the accused applicant. Therefore, he opposes granting of bail to the accused applicants. This court has gone through the case. The court has gone through the trial court records of special NDPS case number 189 in bracket N 2025, which was produced before this court, as well as heard the submissions made by the counsel appearing for the respective parties. After perusal of the case, after perusal of the materials brought before this court, specially the arrest memo, the section 47 and 48 notice, this court did not find any infirmity in service of, in preparation of the arrest memo, as well as serving of the aforesaid notices to the accused applicants as well as their family members. Full stop. In view of the aforesaid, finding no merit in the instant case, the instant bail application is rejected.
My lord, one point I forgot to record. I'm really sorry, ma'am. One similarly situated person has been granted bail. Page 54. That is there, madam. Sorry, my lord. Just now
Your mind is somewhere else or what?
my lord, actually I'm under medication. I'm having some fever actually.
Okay.
That is season
Page
54, my lord. I'm extremely sorry, ma'am.
Who has been granted bail?
My lord, one Noren Borwa.
He is not one of these two persons.
He's not the FIR name accused, but he was also in the case, ma'am.
Okay.
55.
I'll submit. I'll record your submission.
Yes, my lord.
Okay. You record his submission. Where जहाँ पे उसका वो है ना, लेकिन he further, the learned counsel further submits that one of the person arrested in connection with the same case has already been granted bail. Who is?
By the honorable court below, my lord.
Okay, by the
Session judge, some special judge.
by the trial court,
Yes,
same
my lord.
court,
Yes, my lord. Page
by
55.
the trial court, and he submits that aspect of the matter should be also considered while considering the instant bail.
Oblige.
21 and 20.
May please, your lordship. Charge sheet case lordship, offense lordship under 21C of the NDPS Act, lordship, commercial quantity. There are two petitioners, lordship. Petitioner number 1 is behind the, petitioner number 1 and 2 are behind the bar for 196 days. There are 3 petitioners, lordship. Petitioner number 1 and 2 are behind the bar. Petitioner number 3 behind the bar for last 172 days. He was
175 days.
172 days.
Hmm.
And petitioner number 3 was shown arrested in this case.
Hmm.
Lordship, our contention is that Lordship, although 47 Lordship was complied with, 48 was not complied. With regard to Lordship, that Lordship may kindly let me come to the notice part. Page number Lordship 39 onwards. This is 47 Lordship with regard to petition number 1. This is Lordship complied grounds of dear Lordship. Then page number 41. 47 notice with regard to petition number 2.
That's fine, I
Fine.
mean, come to 48 where,
48 Lordship will see page number 44 onwards. This is a 48 notice, but Lordship not served to any family members or relative or any nominated person, Lordship. Lordship may kindly come to page 45. The signature of address is through WT message, email and WhatsApp. And with regard to petition number 2, same Lordship. Page number 47. Same format, Lordship.
I have flag marking.
Through WT message and email and WhatsApp. Page 14.
Mr. Hassan, you tell me one thing,
Lordship.
I mean, this is a certified copy or what?
Certificate.
Certified copy. But those have been received. The signatures are there.
Those 48 notices.
They have been, those have been received. They have put their signatures in the notice. All these notices are, no, 48 notices have been received by the addressee. In case of this Singson,
Things on wife.
then it was received by
Dongel.
Srimati Hetmili Dongel
Dongen, why?
received
48,
48 also. Already these things are received.
they put their signature. Our instruction was that they have not received.
They have received it. They must have, instructed you wrongly.
And the petition number
Now,
3,
it is correct that, it was sent by this thing, but those notices have been properly signed by them. They have received it. They may have sent it through different mediums.
different medium.
Email also, W2 also, otherwise also. And in the notice, they have put their signature of receipt.
Lordship, there may be some delay in receiving, Lordship.
Yes, that when they have received, you have not brought out those materials. Heard, Mr.
And the Lordship,
N. Hassan.
petition number 3, Lordship, there is the contention that the 48 notice was never issued. With
No, it
regard
was
to
there. No?
petition number 3.
It's number 3 also, it is there. Is there? No? Is there?
Lal.
Yeah, when petition number 3, you are talking 48 notice.
48. Lalpu Singh Sid is the petitioner.
What is the name?
Lalpu Singh Sid.
Lalput Singh.
Lalpu
Singh Sid.
Singh Sid.
So Bodo, I'll have to see it, look into it.
Well, regarding Lalpu Singh Sid, I have to verify, my lord. Regarding other matters, I have seen, madam.
His inspection memo is there.
47 is there.
I'll go through one second, ma'am. Go through one second regarding the petition number 3.
You look into it at 2 o'clock, we'll see. Where?
Item 22.
Item
he-
22.
Learned friend is APL.
What is your name? Vijay Verma. Oh, his documents are there. His documents are there.
My lord, I have been apprehended on
Hmm.
2/8, but it was shown arrested on 3/8. The apprehended and arrested, my lord, meaning are same, my lord. Vijay Verma. Allegation against me is that I am the alleged recipient of to be the receiver of the.
But as far as the notices are concerned, that those are complied with.
That after 3, my lord. That is true, my lord. That is after
The
3.
before the production. Before the production, not after this. Only thing is that this person,
Lalpur.
Lalput sings it.
That I know.
He'll have to verify this. It's a voluminous document, so I
Yes.
could not find out. Maybe there somewhere.
I also somehow, I have also missed it.
Huh?
somehow.
Yeah,
I have also
maybe
missed it.
somewhere there. You just check it and then we'll pass the order. 2 o'clock. Please go through it, then we'll take it up at 2 o'clock, this bit. So, as far as your these things are, the both of you, Vijay Verma and the other 2 persons, I have perused, all complied with. There is no problem in that. Arrest memo also, and otherwise this also.
But
Everything
all
is
this
fine.
were, I have been apprehended on 2/8, your lordship,
Hmm.
but that is shown arrested on 3/8,
Hmm.
and thereafter all documents are there.
Hmm.
My contention is
So
that.
you should be given given those notices prior to your production. That has been given to you. That is there.
Yeah, but not immediately, my lord.
Immediately not required. Immediately not required. That latest the case, the Supreme Court has said. That has been specified. The benchmark has been given
2 hours.
before 2 hours. And now if you say like, I was given just 159 minutes before this thing,
That is not like it.
that something like that, if you say, then it will be difficult.
Yes. Later.
This you verified and we'll see.
Applies.
That I have gone through, but it is there, like,
Is there?
it is there.
Lordship, with your lordship's permission, I would like to raise one more point, lordship. That lordship, I kindly see page number 43 of my petition. Page number 43 of my petition, lordship.
Yes, what is that?
There is a arrest memo pertaining to lordship petition number 3.
Hmm.
Which I have checked the record, the 48 is complied with. 47 notice, lordship, may kindly see 43. Yep. Brief of the case is there, lordship. This is the allegation of the FIR. And then detailed grounds of arrest, lordship. No ground has been furnished. As per shown arrest order given by Honorable Court of Special Justice Tinsukia, by order dated 26/8/2025. It is devoid of any ground of arrest, lordship. And this FIR, brief of the case, lordship, this petition number 1 and 2 were lordship apprehended with their lordship contraband of lordship suspected to be heroin, lordship, from one vehicle, lordship. But this petition number 3 was shown as later on, lordship. So this brief of the case cannot be considered to be ground of arrest, lordship. The ground of arrest portion, lordship, has already seen, lordship, it's devoid of any particulars, lordship. That one judgment, lordship. Okay, with the lordship permission, lordship. Small para 28. This Kasi Reddy, Upendra Reddy, lordship.
Hmm.
Para 28, lordship.
So it says, it is not necessary for authorities to furnish full details of the offense.
But
However, information should be sufficient to enable arrest person to understand why he has been arrested.
lordship.
So
Then,
that,
lordship,
so
then
this order 26/8/2025.
that is passed by the learned court below, lordship.
Hmm.
And that he may not have access to that order, lordship. And
Why
what-
he was not there on the date?
He was there, Lordship.
Then
But he was not furnished with the order. This is the order of your Lordship shown in it.
26/8/2025. 26/8/2025, which order is that?
Lordship, I could not annex, Lordship. And one more thing, Lordship, that judgment says, Lordship, the grounds to be communicated to the arrested person should be somewhat similar to the charge framed by the court for the trial of a case. So that is the requirement.
It was by a production warrant.
Lordship.
So he was given a production warrant. So if the court has given a production warrant, why this, separately grounds has to be given? That isn't mentioned here. So it's on the basis of the court warrant. So once it is a court warrant, then this is not required.
Production warrant.
It's a production warrant. The 26/8/2025 order specifically said it's a production
Yes,
warrant.
he was shown notice.
So production warrant, once it is warrant is issued, then grounds are not required to be given itself. If police arrest somebody without warrant, then only this has to be complied with.
With warrant.
Once, if it is a warrant arrest, that is not required.
That warrant itself is a Lordship.
Warrant itself is a ground.
Lordship.
Heard Mr. N. Hassan, the learned counsel appearing for the accused applicants. Also heard Mr. Arzev Borwa, the learned APP for the state. This is an application you write, Hassan? Then you write. An FIR was lodged on 28/2025 by SI Kiran Dihinia of Tinsukia Police Station, alleging inter alia that on 1/8/2025 at 5:54 p.m. on receipt of a reliable information that two persons were coming from Karbi Anglong along with huge quantity of narcotic drugs and psychotropic substances. Riding substances suspected to be heroin in a Bolero vehicle bearing registration number AS-10-A-8037 for delivery of the consignment at Tinsukia, comma. The police team set up a Naka near Borguri bypass, Chariale, at about 6:15 to 6:30 p.m. At 6:15 p.m., when about 6:30 p.m., one Bolero vehicle was coming from the side of Dibrugarh was intercepted. Semicolon, that on preliminary interrogation of the driver of the vehicle, he identified himself as Sri Dehminlan Singson. You take it from here. Dehminlan Singson. And the co-passenger identified himself as Sri Chungmang Singson. Semicolon, that they confessed concealment of NDPS substances suspected to be heroin in the chassis frame of the vehicle, and they were going to deliver the same at Namsai to a receiver. Semicolon, that SI Kiran Dihinia thoroughly searched the Bolero vehicle in presence of witnesses. And recovered 14 plastic packets, usually known as soap boxes, plastic packets. And 14 plastic packets containing soap cases, totaling to 28 numbers. And the total weight of the aforesaid contraband material came to be 318.49 grams of suspected heroin. Semicolon, that the aforesaid suspected heroin was seized by the police along with the vehicle. Next para. On receipt of the FIR, police registered Tinsukia PS case number 284/2025 under the aforementioned sections. Next para. On arrest of the accused applicant numbers 1 and 2, on their information, accused applicant number 3 was soon arrested on 26/8/2025. Full stop. Next, after completion of the investigation, police filed charge sheet number 339/2025 dated 23/10/2025 against the accused applicants. Against the accused applicants and one Vijay Verma. Thereafter, the case was numbered as NDPS case number 6046 in bracket capital T/2025, and the same is pending before the Court of Additional Special Judge, FTC, number 2, Tinsukia. Mr. N. Hassan, the learned counsel appearing for the accused applicant, primarily raised the issue of non-compliance with section 48 notice.
48B.
48 notices in the instant case, submitting that the mandates of section 48 were not complied with while arresting the accused applicants in the instant case. Full stop. He submits that as far as accused applicant number 3 is concerned, in the ground of in the notice under section 47, the grounds of arrest were not mentioned at all. Full stop. In view of the aforesaid submissions, the learned counsel submits that since there is a violation of since there are violations of the mandates of section 47 in the instant case while arresting the accused applicants should be granted bail in terms of various judicial pronouncements of the Honorable Supreme Court as well as of this court. Full stop. On the other hand, Mr. R.J. Boru, the learned APP, submits that there is no there is no violation in compliance with the provisions of section 48 in the instant case while serving notice to the accused applicants. Full stop. Therefore, he submits that the bail in the prayer of bail, prayers of bail for the accused applicants in the instant case should be rejected at once. This court has heard the submissions made by the counsel appearing for the respective parties, as well as has perused the trial court record that has been produced before this court. On perusal of the records, this court has minutely gone through the contents of the notices under section 47 of BNSS issued to the accused applicants and did not find any infirmities in compliance of the provisions of section 48 in serving notices to the accused applicants. As far as the accused applicant number 3 is concerned, since the accused applicant was shown arrested and he was produced before the court under a production warrant, the grounds of arrest in the notice under section 47 specifically mentioned that he was produced because of the order dated 26/8/2025 by the trial court. Full stop. In view of the aforesaid, in view of the aforesaid material which have been duly perused and considered by this court find no merit in the instant bail application, and accordingly the instant bail application is rejected. You have been wrongly informed by your
Wrongly informed.
complaint.
They have told that they have not got anything, but 48.
Another petition, ma'am.
That same order.
Same order, but
His name being
only
right.
my, I have been made accused as I have acted as a receiver of the contraventions. There is nothing has been recovered from me. But I was detained on, my lord, apprehended on 2/8/2025. But shown arrest on 3/8. There is the delay. There is my ground. On merit, nothing has been recovered. But only allegation is that I have acted as a receiver of the contraband.
Acted, you have been, you have been implicated that you are supposed to receive this.
That is the allegation, my lord. There is, you will also may find page 49. And there is one more section was added in my case, my lord, 241 of the BNS.
You are Vijay Verma, right?
Yes.
Yes, 241 is that. What is your ground otherwise?
My ground is that first, my lord, this section has not been complied.
No, those are complied. We
Yeah,
have seen
but
this.
I have been apprehended, just found in the land court below. So I have been apprehended on 2/8/2025. But formally shown arrested, thereafter all documents has been received, everything has been. But after detention, on arrest, on 2/8, nothing has been informed to the relatives of it.
No, I am not getting it. See, you may have been detained. You may have been, police inquired the matter, investigated the matter. After that, they have shown you as an arrest, shown you arrested. And you have been produced in time before the court. So what is the
It was
ground?
produced on third.
Yes. Is it your case that like you have not been produced before within 24 hours? What?
No, he was produced within 24 hours, but
Then-
he was apprehended on.
Then you write one paragraph. The learned counsel submits that though he was arrested on
Arrested on 2/8, my lord.
2/8/2025, he was shown arrested on
3/8.
3/8/2025. And he was served the notice under section 47. He was not served the notice under section 47 in time, and the same was served in a delayed manner. He further submits that the notice under section 47 and 48 were not properly complied with. No, not properly served while he was arrested. Therefore, he should be granted bail at this stage. He further submits that nothing has been recovered from his possession. He was arrested only on the allegation, only on the implication by the accused, by the co-accused, namely
Number 3, my lord, please.
Co-accused, namely
Lampu Sangsit, Lalpu.
namely Lalpu Singsit. Lalpu Singsit. Therefore, he submits that his involvement in the instant case is doubtful, and therefore he should be released on bail. Full stop. Then you write this. Similarly, you write, I'll just correct it here and there.
Right, sir.
So yours also all complied with, I've checked it. APP has also checked it. So 47, 48 complied with, 36 was given to you. Correct. Only thing is that you are saying that, you have been shown arrested later on, but that doesn't vitiate the whole anything. That is not something which is non-pardonable. You can be shown arrested later on also, but you have been after shown arrested. You were produced before the magistrate within time. It is not that you have not been produced before the magistrate after 24 hours. You have been produced before the magistrate within 24 hours.
Apply.
Yes.
23.
এইটো অলপ অনুভৱ ইফালে সিফালে অলপ কৰি ল'ম তুমি অলপ তেনেকে এটা ফৰ্মত মাৰি ল'বা তাত অকণমান ইফালে সিফালে কৰি ল'বা এইটো কেছত ঠিক আছে
Lordship,
য়েছ
so this is an application, this is a case under section 10 of the POCSO Act. At this stage, what my submission is that, Lordship, the 3rd of February was fixed for examination of the victim in the trial court, Lordship. So that was not done, that was adjourned. That was fixed on 27/2. So my submission will be, Lordship, it may be fixed on the first week of the March, Lordship. That apart, Lordship, my another submission is the accused has been suffering serious illness for which he is being brought
No,
regularly.
I mean, Mr. This thing, Mr. Ullah, bail applications will be considered on the basis of the materials or facts
Yes.
which are available on this date. So
Now-
we now we cannot give you an adjournment that, I mean, that your matter will be heard there on such and such date. So we'll keep this pending. That cannot be done.
No, Lordship, then
That
I
cannot
am
be
ready
done.
to hear, Lordship, that apart, another aspect I am submitting, that I have instruction that he has been regularly treating at GMCS, Lordship. That document we could not attach here. So we may also be allowed to submit.
So
on
we'll
this
fix it on the, I mean, fix it in the next week. Next week we'll fix it. You'll bring those documents if there are some medical.
We may be allowed to.
Heard Mr. D. Ullah, the learned counsel, appearing for the accused applicant. Also heard Mr. R.J. Borua, learned APP, as well as Mr. S. Nawaz, the learned amicus.
Not as an amicus, private respondent.
Acha. Nawaz, the learned counsel, appearing for the respondent number 2. On the prayer of Mr. D. Ullah, let the case be listed in the next week on
23, my lord.
24th.
Lordship, we may be allowed to submit additional affidavit.
You can,
Yeah.
you may file. This, Mr. Ullah submits that he should be allowed to file an affidavit, file an additional affidavit to bring in record certain documents, which is allowed by this court.
Public.
24.
May I please, Your Lordship. This is a charge sheeted case, my lord. The sections invoked are 22C, 25 and 29 of the NDPS Act. my lord.
So what is your ground
Uh,
of ground for seeking bail?
The arrest is vitiated by non-compliance with the requirement to produce within 24 hours. This is one, and also non-compliance with section 36 and 48. It is there, and
What one is not produced within 24 hours.
within.
Second,
is non-compliance with section 36 of the NNSS, read with sections
36 and
48.
48.
48. And then nothing was recovered from me. Coincidental presence in the place of occurrence.
What is your name?
My lord,
What is your name?
Shebul Hussain Lashkar, accused number 1 here.
Accused number 1 in the FIR.
1, yes, my lord.
Hmm?
FIR is at page, complaint is at page 19, my lord. The prosecution case that,
Yeah, don't read.
yeah, I'm not reading well. That on the basis of some information that a specific truck is carrying these contrabands, the police set up a NACA there, and when the truck came, along with a Bolero car came, and the petitioner was driving the Bolero car. It was, so they.
So you were following the truck and.
I was actually, I am coming.
Yeah,
on
correct,
my-
but like, I mean, unfortunately, truck
Yes.
was in front of you, you are
Yes.
following the truck.
Yes,
Yes, then.
So I was also stopped along with the truck.
Correct.
And they searched the truck and my car also. They found a modified cylinder loaded with contraband.
Where?
At at the Naka place.
No, where? In your vehicle or the,
No,
in
no,
the
in
truck?
the truck, in the
In the
truck,
truck,
in the
yes,
truck.
okay.
And they
then-
also searched my vehicle, nothing
Mm.
was recovered
Ah,
there.
correct.
So, but they apprehended me.
So
along
why,
with the
why you
other-
have been apprehended?
The police claims that I have confessed that I am involved with
Oh.
this. Only the thing is confessional statement.
So you have been beaten up there in the Naka?
No, Mike, in the police station. I was beaten up in the police
You have
station.
beaten up in the
Though there
police
is
station?
no proof and it's not there.
So you confessed where? In the police station or in Naka itself?
I didn't make confession. The police is saying that I have made confession. So
Okay.
this is one of the other things.
Acha, and what about the truck driver and all?
A truck driver is arrested.
The driver did not implicate you?
Yes, truck driver is.
Implicated you?
Yeah.
So
yes,
why are you not saying that?
Yes, I'm going to that.
So that is the main thing, no? I mean,
But
you,
this is
you,
the-
you,
this is this
no, no, see, you are trying to make a story as if as a gentleman was driving a vehicle behind a truck was intercepted. Then because the truck was intercepted, you had to stop there. Then suddenly something was found in the truck and you have been also arrested.
This is
Because you were beaten up.
this is my defense, my lord. But the prosecution case is different. That
Okay, then
prosecution-
47, 48, you tell me where you have annexed?
No, my lord. Before going to 48, my lord, I would like
So
to.
you say, you said you were not produced
Produced before 24
within
hours.
24 hours.
Yes.
You show
So-
me, show me from where you are saying this?
No, the page 20, my lord.
Page 20.
Page 20, my lord, there, this is the FIR.
Yeah.
At 7:20.
Hmm?
At 7:20, I was apprehended on 6/9.
One second. You were apprehended on
7:20 a.m. on 6/9/25.
6/9 or 9/6?
9/6, sorry. 9/6.
9/6/2025 at what time?
At 7:20
7:20 a.m.
a.m. as per FIR.
Okay, 7:20 a.m. on 9/6,
Yes.
right? Then
I was shown arrested on next day, 7 a.m.
from where you are saying?
This I have not annexed, but on the charge sheet at page 27,
Yes,
it says 10.
it says
Page 27, 10/6/25. I was arrested, but time is not there. Time, your lordship will find this notice under section 47, 48 and arrest memo.
So bail application number কিমান?
25.
Page না মিলা নাই তো আপনার 27 search it.
27.
now from where you are saying that you have been produced
So-
beyond 24 hours?
So arrest was shown at 7 a.m.
No, arrest, you were arrested on 10/6.
I am apprehended according to the FIR at 9/6 in the early morning, 7:20.
Now from where you are saying, so which paragraph?
There is page 20, ma'am. Page 20.
Please?
20 of the petition. At about 7:20, we have noticed, so the descriptive vehicle approaching towards so-and-so, descriptive vehicle is truck.
Yes.
So,
So does it mean that you have been arrested?
yeah, here it says, I was apprehended, and it means the actual apprehension is the actual arrest. I'll submit some
No,
judgments on-
where, I mean, at 7:20 PM,
Yes.
vehicle approaching so and so. Right?
Accordingly, both vehicles stopped at the roadside,
Yes.
maintaining slight distance from each other.
Right.
When the truck stopped at the roadside, I have
Hmm.
noticed a registration number
Hmm.
matched with the description provided by the.
This is which place? This is which place?
This is the.
Naka where?
Yes,
Naka where?
the place is called Sunabari Ghat
Huh?
bypass.
What Sunabari Ghat?
Sunabari Ghat bypass.
Sunabari Ghat bypass, yes. This is near?
This is near Silchar.
How far is from Silchar?
It would be approximately maybe 10, 12 kilometers. I cannot say for certain.
Hmm?
Approximately 10, 12 kilometers it should be. I cannot say for certain.
Okay.
So accordingly, I along with my team approached towards Mohindra Bolero bearing register number so and found person on the driver's seat who identified himself as Sebul Hussain Loskar. This is the petitioner. So and so and headdress. Therefore, we approached towards staff. So and so.
No, I'm sorry, my lord, sorry to interrupt at this moment, my lord. My lord, the bail application, my lord, I am holding, my lord, this is not matching with the, my lord, petitioner's bail application, my lord. So, my lord, I may be allowed some time, my lord, to go through. Them. Because, my lord, this is the petitioner is also Sebul Hussain Loskar, my lord. And.
But
this is-
the bail application is different.
Yes, it is from, my lord, Kamrup district, my lord, that is why.
No.
Sebul Hussain, NDPS case number 229, again, no,
No, identification 78.
It is different, my lord.
So we'll fix it on some other day, Monday.
I'm behind bar for 249 days. My
Hmm?
lord. 249.
Yeah,
days,
I
and
understand.
Apparently the arrest is vitiated. Apparently the arrest is vitiated for.
That has to be seen, that has to be seen.
Yes, my. So that's why
Huh?
an early date,
Yes, some,
Monday,
Tuesday we'll fix it,
Tuesday.
Tuesday. Let the case be listed on,
Tuesday, that matter is fixed, my lord, Delhi matter.
which one?
Delhi matter, my lord.
Oh, that is there, huh?
But let it be on Wednesday, my lord. It might take
What
some
about
time.
Monday?
Wednesday we'll fix it. Monday we have fixed already a lot of matters. So Wednesday we'll fix it.
Fine.
Wednesday we'll consider your things.
Fine.
Get a matter fixed on Wednesday.
25.
Okay, that is not received, my lord.
Is there not received? Let the matter be listed in.
This
the-
year may be called.
TCR.
This year may be called.
TCR may be called for, my lord.
But, along with the case there you want.
Along with the case that, my lord. This is Harshit matter, my lord.
But TCR was not called for.
It
called-
was not called for happening.
Okay, heard Mr. So-and-so, the counsel, for the experience, and also heard so-and-so. It is submitted the TCR, in the instant case was not called for. Therefore, registry to call for the TCR. In connection with special NDPS case number 55/2025 from the Court of Learned Special Judge in bracket NDPS Lakhimpur, not Lakhimpur. Let the matter be fixed on 25th,
27, my lord.
27th will be difficult.
25th then,
26th or 25th.
my lord.
2050.
20
26.
Item 26 service report awaited, POCSO matter.
Heard Mr. So-and-so, APP. Then you write, service of on respondent number 2 is still, then a report of service on, report of service of notice of respondent number 2 is still awaited. Let the matter be fixed on, on 26th.
Can it be earlier, my lord?
No, not earlier, 26th, can't be before this,
Can it be on 23 or 24, my lord?
26th.
28.
28 also service report awaited. Steps taken on 30th of January.
Okay, heard Mrs. So-and-so, so-and-so. As per the office note dated 31/1/2026, the service on respondent and, service of notice on respondent number 2
29.
has not been completed as yet. Let the matter be fixed on, fixed on 26th.
Session.
29.
So last occasion when the CD was examined by this honorable court, your
Mm,
lordship,
mm.
lordship, nothing materials found against me, but in the PM report was not in the CD, my lord. Now, my lord,
Your report has come.
PM report has not come, my lord.
my lord, non-compliance of this judicial order itself is.
No, my lord,
count
PM
for-
report has
My
not
lord,
been received.
Then we'll have to put all the police officers behind the bus.
No, that's true, my lord.
Huh?
My lord, in this case, my lord, for a moment to refresh.
No, no, no. I mean, we'll fix, I mean, but see, last time I have seen this guy, I remember this
Yes, yes.
case. I mean, the only thing is that like, let this come, because without that, I mean, it will be difficult
Then,
to
my lord,
execute.
in the AB case, my lord, that police is searching, my lord, that 25 is going, my lord, police is searching. and
We'll fix
my
it,
lord,
we'll,
Interim protection, kindly.
when can you get it?
My lord, today is 13, my lord, may fix kindly on, my lord, 24th.
24th.
24th, my lord.
My lord, in the meantime, my lord, I may be protecting the
One
two AB matter, my lord.
They have
My
to
lord,
send
I-
back, they have
my
to
lord,
send back the
otherwise,
CD.
Hmm?
They have to send back the CD and we will produce up to the CD with PM report and all this.
Series with you now.
Yes.
CD receipt.
We'll have to send it back.
Malat
Or you can get it, we can get it, I mean,
Yes, Malat, for the PM report only. Malat.
only PM report only we require. Heard Mr.
My lord, my lord,
K.
before that
Das,
passing, my lord, I want to place one judgment, my lord. Satisfactory.
judgment of what? No, why, for what? It's a POXO matter.
No, my lord, this is
What?
Not
matter, my lord.
What was that?
My lord, that is why, my lord, I am paying, my lord. 69 days, my lord, in custody, my
The
lord. for-
postmortem of, oh, this is,
Yes,
yes,
my
yes.
lord,
yes.
30, my lord, kind of for,
Mhm.
kindly, my lord, there is that affair, my lord.
Mhm.
For
No,
a
no, no,
moment,
no,
my lord.
I got it.
So if only PM report, my lord. This is the
Mhm.
fourth occasion that
How-
case is listed, my lord. And that police earlier occasion, they are not placing that postmortem report. Now is that the place of occurrence is 72 days today, my lord. And they are not placing the postmortem reports, my lord. Nothing against us, my lord. in the
Malat may fix
material-
kindly on next Friday. Malat.
No, my lord, my AB may be, my lord, consider, my lord. Police is searching day to day.
Where is your AB?
AB 41,
41 and
is the same
42
as-
connected.
40 and 42 you give.
My lord, at least, my lord, a young boy, my lord, 25 years, my lord, and another that boy, my lord, 31 years, he's a married man, my lord. Police is searching, my lord. We are ready to cooperate any investigation, my lord, whatever condition imposed, my lord. It's 13, my lord, nothing, my lord. Only because of civil nature, my lord, first part.
Death is Malat suspicious.
No, it was a case, no, that's what, no, it was a, I mean, it was a case of minor girl, I mean, who was, I mean, I wrongly spelled out POXO, but like it's a case of minor girl who was been killed.
No, my lord, here is a, that minor girl, my lord, according to that affair said that, my lord, minor girl who offered me to marry, my lord.
Hmm.
That I refused, my lord, only because she is cousin, my lord, according to him. And first part, kindly look into that, my lord.
No,
I
I'm talking about allegations, Mr.
That is, but
Allegations.
there is no specific, and my lord, CD is before your lordship. If any materials found again, ask my lord, we are ready to, whatever this honorable court,
but-
my lord. Only because of the PM report, my lord, last thing, and police is searching, my lord. I want to place, that is why, my lord, Jagadish Tagis are feeling, my lord. This is the effects of them. At least, my lord, we are.
What is there in the city, Mr.
Fact
Paras?
is that,
There
Malat,
is the city, my lord.
how died Malat, that is not Malat before us, Malat. Because of the PM report is not there. Death is suspicious. Something has been eaten, Malat, and subsequently that girl was found dead. So
We'll keep it
PM is
a
very
short date.
My lord, that is why, my
Well,
lord.
we'll keep it-
We
we'll-
are interimly protect, my lord. For a moment, my lord, kindly.
next
I
week,
want
Malat,
to
any
place,
date,
my lord.
Malat, next week.
I want to place, my lord. Police-
Okay, Mr. Parasar,
19 or
Mr.
20.
Parasar, you give me the CD, what is there, let me see.
Yes, my lord. Kindly pay, kindly.
19
examine
or
the CD.
Let me see what is there.
19 or 20, I can produce one. Relatives and family members, they have stated that petitioners are involved, but
22 pairs.
how?
No, what do you want to say with this case?
In this case, my lord, what happened, my lord?
No. In this case, by what ratio it has been laid down?
My lord, in this case, my lord, only because said that, my lord,
No.
how we kill,
No,
my
no,
lord, there is
no.
Supreme Court.
In this case, Supreme Court has said what?
Primary.
No, then Delhi High Court. First of all, Delhi High Court is not binding.
But para is that, my
No,
lord. said
Delhi
that,
High Court is not binding in this court.
That's but it's
First of all-
quoting is by the Supreme Court judgment, my
No,
lord.
now, I understand. I mean, now what do you want to submit with on the basis of this?
Yeah, it says the primary case has to be make out, my lord.
Correct. That's what I'm saying.
Kindly peruse the CD, my lord. Police is searching day and night, my lord. We are ready to cooperate, my lord. Young boy, my lord, if sent to jail, my lord, then, my lord. Kindly, if lordship found any materials, my lord, I have no objection, my lord.
The cause of death is very vital, my lord, in this case actually. Because the girl how died, my lord, if as per the statement of the my lord, family, friends and all this, she was killed, but actual fact has to be, my lord, ascertained from the postmortem report.
Mr. Das, see, if there are some materials against you, huh? Be patient and hear me out. There are some materials against you. Allegations such as, without telling anybody, you have put down the dead body and kept it there. Then you say that she killed herself by hanging. So some allegations are there. Now, if you want this court to consider your bail now, then it may be difficult for you only. That's what I'm saying. What I'm suggesting that let the postmortem report come. If postmortem report comes, then it will be clear whether, at least some, idea will get whether it is a suicidal death or it's a kind of a killed, killed and it was hanged. So some kind of this thing will come, then it will be better for you. But at this stage, if I consider on the materials, on the basis of the materials before me, then it will be difficult for me to give you this thing. That's why I'm saying, you wait for the postmortem report. Then if postmortem report comes, we will consider this.
16, my lord.
No, 16, how, my lord, today is 13, tomorrow, day after tomorrow is
17,
holiday.
my lord.
They will, my lord, 19, my lord, maximum, my lord.
18.
18.
18, I have a problem. I will be out of station, my lord. 18 and 19, my lord.
17 আকৌ এনেকুৱা হ'ব। আকৌ এনেকুৱা হ'ব। 20 is 20, my lord, Friday.
See, the council appearing for bail matters should not worry about going out of station and all.
Understand.
They will always be there.
Understand, my lord. My lord, on that day-
Because you are taking the cases, involving personal
No, I
liberty,
understand.
involving
No, my lord,
life
some
and death.
matter is fixed in Manipur High Court, my lord.
Okay, well, when do you want?
20, 20,
20?
20.
Administrator, your नाम तो लिखिएगा, हाँ। Let the matter be listed. The right postmortem report and a postmortem report in the incident case was called for. How the same is not received today. let the matter be fixed on 20
20.
to 2026.
Itu নহয়, itu sir.
Regular,
CD notice, my lord.
no, 19 is behind the bar, lordship.
What?
Only, my lord, 4.73 kg, 70 kg, my lord, ganja, lordships.
How much?
27 A is there.
My lord, intermediate quantity, lordships. Page 12 is the affair, lordship.
But 27 A is there, my lord, because of that, my lord.
That, my lord, only 4.73 kg, lordships, ganja. So, my lord, intermediate quantity, lordships. On the length of the 93 days behind the bar, lordships. So, on that ground, I may be granted bail, lordships. Local people, lordships. They belong to Assam.
That is not a ground.
Hello.
What, Mr. Parasar? Intermediate quantity of
No.
ganja.
Lordships.
Ganja in intermediate, but 27 A is there because of, yes.
There is only ganja, lordships.
And this, they are very young people,
Yes, lordships.
22 and 19 years. Both are husband and wife or what?
No, lordships.
No.
They are siblings,
Yes.
siblings,
They are friend,
brother and
lordship.
sister.
No, lordship, they are friend, lordship, actually. Cousin.
Acha, both are males, no?
Hi, lord.
Male.
No, my lord, kindly consider, lordships. Only 4.73 kg.
Regarding my lord, 27 A, my lord, 37 embargo will come. Otherwise, my lord, CD is not there.
The
27
intermediate quantity.
Yes.
intermediate, but 27 A is also there.
27 is what?
27 harboring and financing, my lord. In that case also, my lord.
My lord, only 4.73 kg ganja. Intermediate quantity, lordships. And 93 days behind the bar. Police got the sufficient time, lordships.
Yes, CD can.
Kindly consider, lordship.
Not looking for.
How much quantity for?
My lord,
From one
4.730 kg from one
Four-
and
4.7
730
kg from?
from my lord, one
no, white color ganja.
The total how much?
total lordships, 4.8.
From one 4.960 kg and from one 4.730 kg.
Almost 9
Around-
kg lots. Total 9 kg. 12.
Around 9 kg.
Almost 9 kg lots. From both of them lordships.
Separate packets.
Intermediate quantity lordship is still.
Heard Mr.
M.
What's your name?
M. Hawk lordships.
M. Hawk, the learned counsel, appearing for the accused applicants. Also heard Mr. K.K. Parasar, the learned counsel, the APP for the state. Then you write the decision application, you write, huh? Application you write. An FIR was lodged on 12/11/2025. By one Dipankar Changmai of North Lakhimpur Police Station before the officer in charge of North Lakhimpur Police Station, alleging inter alia that on 11/11/2025 at about 8:30 p.m. An information was received from reliable sources regarding the accused applicants who were carrying narcotic substances from Udalguri to Lakhimpur on a bus. semicolon D that that on such receipt of the information, the police team apprehended the accused applicants and during the search, the police recovered 4.96 kg of ganja from the accused applicant number 1, whereas 4.730 kg of ganja from the accused applicant number 2. On receipt of the FIR, the police registered Nokhimpur PS case number 380/2025 under the aforementioned sections. Okay. The learned counsel appearing for the accused applicant submits that the ganja seized are of intermediate quantities, and the accused applicants, who are young boys of 22 and 19 years respectively, have been detained by the police, and for last 97 days, 93 days, they are behind the bars. Behind the bars. He submits that the accused applicants are not habitual offenders without having any earlier criminal antecedents, and therefore taking into account their time spent behind the jail, they should be allowed to go on bail. First. On the other hand, the learned APP submits that case diary in the instant case is yet to be, case diary has come, oh?
Case diary is not.
Case diary in the instant case is yet to be received, and therefore, without perusing the case diary, the accused applicants should not be granted bail at this stage. This court has considered the submissions made by the counsel appearing for the respective parties. Full stop. Taking into account of the fact that there is no material before this court to show that the accused applicants are habitual offenders with criminal antecedents, and also of the fact that they are young boys of 20 and 19 years, and they have already spent 93 days of 93 days of 93 days less than 93 days behind the bars. This court is of the considered opinion that further custodial detention of the accused applicants may not be necessary in the instant case, and therefore it is directed that the accused applicants shall be released forthwith from jail on furnishing of bail bond of rupees 30,000 each with a surety of like nature to the satisfaction of which court, to the satisfaction of
Learned special judge,
Learned Special Judge and
Lakhimpur,
NDPS Lakhimpur,
not Lakhimpur.
not Lakhimpur, subject to the following conditions, that the accused applicants charge sheet not filed, no? Not filed. Accused applicants shall cooperate with the investigation and shall make themselves available as and when required by the investigating authority. The accused applicants shall not try to hamper or tamper with the investigation of the case. The accused applicants shall not indulge in any activities relating to sale purchase of narcotic drugs, narcotics, contraband materials. In view of the aforesaid directions, the instant bail application is disposed of as allowed.
And the problem. 31.
May it please, my lord.
Hmm.
POCSO matter. Behind the bars since last 280 days, my lord. My lord,
Notice,
all
notice, somebody is appearing.
Notice he is appearing.
You are appearing. Informant, you are appearing.
Yes.
Okay.
lordship,
Yes.
my lord, the statements of all the PWs have been completed.
What is your special case number?
My lord, special case number would be, my lord, 179 of 25.
Oh,
Nagaon special case.
Correct, 179 stroke, in bracket 9 of 2025, produced before this court, After, in consideration of the materials available in record of the trial court, and taking into account of the fact that that the trial is proceeding in a reasonably good speed, and the same is expected to be completed soon. This court doesn't find any merit in the prayers made in the instant bail application at this stage. In view of the aforesaid, the instant bail application is rejected at this stage. Mr. Sharma, both the cases you have today, I don't have good cases with lot of merits.
God's plan, my lord. Someday I'll get good cases.
Some other day good
Some
cases.
other day. Oblige. I'm deeply obliged.
Don't lose her.
Problem. Deeply obliged, man.
You tried your best.
I'm obliged, man. I'm really deeply obliged for the patient hearing, my lord, from this honor.
Hey,
Yes.
Lordship. Lordship, probably here, 60 days with the statutory period, and petitioner has spent 39 days, starting from 6/1, Lordship.
What petitioner has?
Spent 39 days, Lordship.
39
and
days.
Yes, Lordship, nothing, intermediate quantity, Lordship, and nothing has been recovered from the position of the petitioner. And the incident refers to a date, Lordship, of 1810. Page 10 is the FIR, Lordship. And sorry, page 9, Lordship, FIR. It refers to an incident of 18/10/2025, where admittedly I have made certain statement in my petition, Lordship. Earlier petitioner was arrested and thereafter he went to police station to collect his mobile phone. There was considerable delay in filing JIMA petition, and thereafter Lordship he went to police station and there he has been detained. So nothing has been recovered from his person.
From an abandoned scooty, my lord, the contraband will seize from a scooty. And now the accused, my lord, he, in his statement, my lord, he stated that, my lord,
He went to
on
take the Jimma of the vehicle. What?
Jimma is, vehicle is not from him, my lord.
Not vehicle, Lordship,
Huh?
mobile.
Mobile was.
No, mobile, Jimma of the mobile.
On it.
He was, earlier he was arrested
Hmm.
in 30 in the same PPS. So there was delay in filing JIMA, that is, and thereafter he went.
With which one? Arif Ali, my lord, he is doing all this, my lord. যোৱা 18-10 তাৰিখে আৰিফ আলীৰ লগত এখন স্কুটিত ড্ৰাগছ লৈ অনাটো সঁচা। আৰিফৰ লগত বহুত দিনত বেপাৰ কৰে, মই তাৰ লগত পাৰ্টনাৰশ্বিপত কৰো। They are the peddlers, my lord.
Judicial confession, Lordship. Mine, prior at this stage, he has spent, on 6/1, he has arrested.
37 gram without box. Suspected drug.
Suspected heroin.
My lord.
Yes, Lordship.
FSL report not yet received. So.
What is there in the statements? Anything else?
My lord, he one along with one Arif Ali, he is bringing those, my lord, seeing the police, they my lord, left the vehicle, my lord, scooty.
So, I mean, seeing the police, they fled away,
Fled away.
abandoning the scooter and
Man.
scooty that those recovered. Bad case, madam. At this stage, no.
That's also not there. It's suspected that much, Lordship. Fixing a date, Lordship, because 60 days offense, he has already spent 39 days, Lordship.
Is there an admission of that being heroin?
My suspected heroine, my lord, that is there, my lord. Suspected heroine.
Then in their statements?
Yes, in their statement they have stated. India stated they have drugs or ব্যাপার করো. But FSL not is 38 days to them.
It is done, Lordship, it's another.
Yes, Mr. Parasar.
For FSL, madam.
Heard
Madam, fix
Mr.
on
T. Som, right? T. Som, the learned counsel appearing for the accused applicant.
26.
Also heard Mr. K. Parasar, the learned APV for the state. This is an application, you write, application. Then it is submitted that FSL report regarding the
26.
suspected narcotics seized is yet to be received. Is to be received. Was it called for?
Madam?
It was not called for, no, FSL report.
FSL report, no.
Usually comes with the CD.
Yes, usually come in the CD. Madam, CD it is not yet received, madam.
FSL
Fiction, madam, 24 or 26.
FSL not received, though the CD has been received.
No.
Await for the FSL report. Let the matter be listed on
23rd, madam.
23rd. No, 20 no possible.
No, it will not come.
23rd. 23rd, yes. CD has come?
So in this case, Lordship, the learned session judge already granted bail to the co-accused, Lordship. I have the order, Lordship. May I tell you it, Lordship?
I was seeking
In this
another.
case, Lordship, the court has already granted bail to the other co-workers, Lordships. I have the order, Lordship. Kindly peruse, Lordship.
14 days behind your bar.
I was seeking another date, matlab CD not received.
They granted bail, my lord, final honor. Put below Lordships. Kindly sit down ground.
PDPPA.
Same day they were arrested, Lordships. And accused number 2 granted bail by the learned court below, Lordship. So I am on the same footing, Lordship. So my lord, I will also grant bail, Lordship. Today is 40 days. We are not naming the affair, Lordship. The articles already recovered, Lordships. Only theft, Lordships.
Let the CD come, matlab short date may be given.
The
matlab.
bill.
But nothing is there. I mean, or Mr. So-and-so, the learned counsel, appearing for the accused applicant. Also heard Mr. K.K. Parasar, learned APP for the state. An FIR was lodged on 21/12/2025.
Maybe.
By the headmaster, right?
Lordship.
By the headmaster of Dinanath Sohoria High School, alleging that some unknown persons have stolen some tele-education articles from the school. On receipt of the FIR, police registered Mongol Day PS case number 06/2026 under section 305 in bracket small e of BNS read with section 3 of PDPP Act. Full stop. When you were arrested?
4/1, 4/1.
4/1/26.
Today is 40 days.
The accused applicant, the accused applicant was arrested on 4/1/2026 and for 39 days.
Yes, Lordship.
Last 39 days, the accused applicant is behind the bars. Full stop. The learned counsel, appearing for the accused applicant, submits that the accused applicant was not named in the FIR. However, police arrested him only on the basis of suspicion. He further submits that some of the co-accused who were arrested on suspicion were granted bail by the additional session judge, FTC, Dorong Mongolde, wide its order dated 9/2/2026. He submits that the accused applicant is no way connected to the offense as alleged in the FIR. He has been arrested only on mere suspicion. Next, the learned APP submits that case diary in the instant case is yet to be received. So his bail application should be, the instant bail application should be considered only after receipt of the case diary. Full stop. After this court has heard the submissions made by the counsel appearing to the respective parties and on consideration of the fact that the accused applicant is not named in the FIR and arrested on suspicion, and also taking into account that some of the co-accused have already been granted bail, is of the considered opinion that the accused applicant should be granted bail at this stage, taking into consideration the length of his detention of 39 days inside the jail. Accordingly, it is directed that the accused applicant shall be released forthwith from jail on furnishing of bail bond of rupees 20,000 with the security of like nature. So, like nature, to the satisfaction of the
Chief Judicial Magistrate, Dorang Mongol.
Chief Judicial Magistrate, Dorang Mongoldo, subject to the following conditions. Just give two, three conditions. In view of the aforesaid direction, the instant bail application is disposed of.
I'm deeply obliged.
45. It is all over. Regular bail forest offense, my lord.
Mm.
The FIR, my lord, as from page 14. But certain birds were found, or carcasses of birds were found in a paddy field. My lord comes to page 14. My lord, it's a long FIR.
Mm.
But initially, applicant number 2 had pointed it out to them about the dead birds, helped in their
Dead
search.
birds were
In a paddy field in Majuli, my lord.
in a paddy field in Majuli.
Majuli. My lord,
Okay.
we are.
Grey goose, grey goose,
Grey goose,
all migratory birds.
migratory.
Hmm.
My lord, we manage.
A lot of stories about grey goose, huh? We used to read in our, I mean, growing days.
Yes.
Yes. Then?
My lord, may I read that? With reference to the subject cited above, I most respectfully submit this first information report for your kind information and immediate necessary action regarding a grave and serious incident of illegal hunting, poisoning, killing, possession, and intended sale of migratory birds, namely grey-leg goose, which has occurred within your jurisdiction and which directly affects wildlife conservation and ecological balance. That on 26/1/2026 at about 11 a.m., reliable information was received that migratory birds were being illegally poisoned and killed at the backside paddy field of Kamargaon village. That immediately after receipt of the information, I along with my staff rushed to the place of occurrence. On reaching the spot, it was observed that many migratory birds were found in poor and abnormal conditions, showing signs of poisoning. Further, 3 migratory birds were found dead at the spot and many number of birds were found injured due to poisoning. That the said 3 dead birds and the injured ones were handed over to the Forest Department officials for further examination and necessary legal procedure. During preliminary inquiry at the spot, it came to light that some persons had deliberately used puradhan chemical, poisonous substance. One of this puradhan chemical is, my lord, a pesticide. It's carbofuran, which is used in rice and other agriculture. That's a commonly used pesticide.
Used for what?
My lord, in rice and rice cultivation as pesticide.
Okay, while cultivation, as pesticide.
It's
Okay.
pesticide.
Okay. Not as preserving material or something.
No.
Okay.
It's used as pesticide.
Pesticides, okay.
In the said paddy field to kill the migratory birds with the intention of using meat for consumption and also for selling. That subsequently, during inspection of the said paddy field, carcasses of several migratory birds were seen lying scattered in the field, which clearly indicated death due to poisoning. Feathers were also found in the surrounding area, further confirming the occurrence of mass killing. After handing the injured migratory birds and dead ones, I returned back to Bongaon OP. Again at 1:50 p.m., reliable and credible information was received from local sources that some persons of Kamargaon village had intentionally used puradhan chemical, poisonous substance in the paddy field located at the backside of Kamargaon village with a pre-planned intention to kill migratory birds, which regularly visit the said area during the winter season in Majuli. On receipt of the said information, I, along with staff, namely UBC so-and-so, visited Kamargaon backside in the paddy field. A search operation was conducted at a camp-like house situated near a fish tank close to the place of occurrence. During the said search, all the below noted accused persons were found present near the camp-like house, which strongly suspects their involvement in the offense. This is the allegation against me, that the migratory birds like grey-leg goose travel thousands of kilometers. Rest, my lord, it's on the other parts, my lord. My lord may come to the next paragraph. During careful search of the said camp-like house, the following incriminating articles were recovered and seized in the presence of available witnesses. 1 plastic packet, color white. Inside found puradhan chemical, poison, feathers of migratory birds, grey-leg goose. The recovery of the above article clearly establishes that the below noted accused persons were engaged today in illegal killing of grey-leg goose and possession of migratory birds, and the birds were intended for meat consumption as well as for selling for financial gain. The acts of the accused person amount to heinous offenses, so and so. My lord, one thing my lord may notice.
How many?
17 persons were arrested. I represent 3. My lord may kindly notice the age of the persons who have been arrested. In page 15, my lord, serial number 2, Srimati so-and-so, 60 years. First is Srimati so-and-so, 35 years. Then another lady, 35, another lady, 45 years. Then another person, 45 years. One 20-year-old boy. Then next page, my lord, 35, 55.
Now, why the age? Why the age?
My lord, these are elderly people. My lord, 60 years persons are also there. Will they be involved in such an offense? These persons were present there. It's a bill, my lord. It's known as NIDO bill.
But 60 years people also eat,
Yes, ma'am.
non-vegetarian food.
Of course, my lord. Especially here, my lord.
Uh-huh.
In this part of the country, it is. But, my lord, will they be involved in an illegal killing of birds?
Now, tell me one thing. Mr. Bhattakur, this furadhan is a poison?
From this report, it seems, my lord, we have received the CD. It is, my lord, voluminous, and actually, my lord, last occasion, my senior, my lord, B. Sharma appeared here. But my lord, may fix it on Monday, my lord. I would like to go through the CD, my lord. On Monday, I'll be.
But
able
the matter was listed. You got to know about this matter day before yesterday.
Yes, my lord. But I was.
Were you busy with some other cases?
No, my lord, but this was assigned to Mr. B. Sharma, my lord, and he had some difficulty today. So Monday, my lord, may fix it.
These persons are, my lord, actually innocent persons.
See,
Yes, I understand that.
they are behind the bars. They are behind the bars. They are villagers. So, how many days?
18 days till today.
18 days.
18 days. And Furadhan, my lord, I did a Google search, my lord. If I may be permitted to read it.
Yes, yes.
Carbofuran, the name is carbofuran. Carbofuran, a highly toxic carbamate insecticide, nemacide, and miticide used to control a broad spectrum of pests in agricultural crops such as rice, vegetables, and fruit. It works as a systemic pesticide, blocking the enzyme acetol something, my lord, a bit unpronounceable.
Okay, we'll give him some time. Monday we'll take it up. Monday you tell us that furadhan is. What are the uses of furadhan? Usually in the villages of that part, whether it is used or not, or was it like something like that? It was specifically procured to kill those. So all these things you'll have to place before this court. Because of the reason that like you have arrested them only on suspicion because they were there. And if, now cultivation is, what is the stage of paddy cultivation now? Any idea? Now it is today, now the crops are, now crops are not there.
It's not there now.
Crops are not there.
Mustard cultivation. Oreo.
But in the same field, they are doing mustard cultivation. See, those are important factors. You please let us know.
There, my lord.
Now it is being, paddy is not there.
No, my lord, there is some paddy like mustard oil cultivation is going.
Mustard oil cultivation. In the same field from where this,
Yes,
from where this, birds were found,
Yes,
killed birds were found.
Yes.
It's from that locality.
Okay, okay, we'll see, we'll consider, on the prayer of Mr.
Tuesday, my lord.
Tuesday. So you want your people to be behind bar for one more day?
They be permitted to appear to see on.
No, okay, Tuesday we'll keep it. Tuesday we'll keep. On the prayer of Mr. I. Bhattakur, the learned counsel appearing, this thing, no? Standing
On
counsel.
behalf of the Special Public Prosecutor, Wildlife, my lord.
Okay, so wildlife, let the matter be listed on Tuesday, that is on 17th.
Deeply.
Obliged.
But Tuesday we have a lot of matters, that other matter is also there.
My lord, may I pray, can it be on Wednesday, my lord? Tuesday, I might not be there, so
So B. Sharma will be there or you'll be
yes,
there?
he may not be there, my lord. That is why on Monday or my lord, Wednesday, if.
So Wednesday we'll fix it.
Obliged.
46.
Sashit, CS number 9/26 dated 10/26.
Heard Mr. R. Ali, the learned counsel, appearing for the accused applicant. Also heard Mr. K.K. Parasar, the learned APB for the state. This is an application, you right? he submitted a charge sheet in the instant case has been filed by charge sheet number.
Case number 09/2026,
Mm.
dated 10/2/26.
In view of the aforesaid, the learned counsel appearing for the accused applicant submits that he may be allowed to appear before the trial court for appropriate relief. In view of the aforesaid, this instant bail application is closed and disposed of. Bail hearing হবে কিমান আছে? Bail hearing আছে। Yes.
May I please your lordship, my lord? Here, my lord, petitioner was arrested, my lord, after 6 months after, my lord, 50 days of the incident, my lord. He is behind the bar for last 186 days. There is a reason, my lord. I am submitting this, my lord.
How many days? One?
After, my lord, 5 months of the incident, I was arrested in this case.
After 50 days, you said?
50 days, my lord, 50 days.
Yes.
And I am.
50 days and 5 months are different, Mr. Chaudhary.
Yes, my lord.
5 months is 150 days.
150 days. I am behind the bar for, my lord, 6 months, 3 days, 186 days.
186 days. Okay.
Yes, my lord.
Okay.
Yes, my lord. Basically, my case is, my lord, 36, 47, 48. Considering this, my lord, co-accused is already been enlarged on bail. Except me, my lord, all are out, my lord. From whose possession has been recovered, all are out. Well, one order has been I annexed, my lord, 12% of recover, and 2 order, my lord.
And then what I was saying, that all accused persons are enlarged.
Except the petition, all accused person is released on bail. Yes, my lord. I am giving the factual background of this case, my lord. Your lordship, kindly come to the first 36 notice, my lord.
Page.
Yes, my lord, I am coming, my lord. What page to Page 42. Lordship, here, my lord, they have to mention all the basic facts, my lord, in the memorandum arrest also, my lord. As per DK Basu case, my lord. That was not done. And most important thing is that, my lord, in that notice, my lord, if your lordship go, my lord, your lordship will file signature of a witness. Page 40, have you got it? 42. This person, my lord, I could not, my lord, hear his name, I could not read the name, but as per instruction of my client, my lord, he is a police officer, my lord, of the NCB official, my lord, which is clearly covered by.
See, on this ground, I mean,
Yes, my lord.
already bail has been granted.
I annex, my lord, same bail, my lord. A person was released on bail, my lord. Then, my lord, your lordship kindly come to the telephonic intimation of arrest, my lord. They given telephonic intimation of arrest, my lord. If your lordship read, my lord, on that after Anshu Kumar, so and so, he talked the father on his mobile phone number and intimated him about the detail of arrest, my lord. No ground of arrest, nothing has been given, my lord. Although this is not acceptable as per judgment of Kabir Purkasta paragraph 20, and my lord, Pankaj Bansal has categorically stated. Then your lordship kindly come to the next page, 44.
Yes.
Yes, my lord. My humble submission before your lordship, they only intimated that he was arrested. And when this notice was given, my lord, at the time of production of the accused person, after the production of the accused person, my lord, this notice has been given, my lord. And that will not surpass the full surpass of the.
Now,
yes,
how do you say it is after the production?
I have stated in my petition, my lord, and your lordship kindly go to the, my lord, 13/8/2025. And in fact, here is the question, no? Page 48, my lord. The Angshu Kumar had given information of his father and Vishwanath telephonally after his arrest. And further intimation of arrest, was sent via speed post, also served to his father, namely Vishwanath Singh on 14/8 today at the court premises, Patna. When he was produced, my lord, thereafter this notice was given, my lord.
So, I mean, you are saying that this person, Vishwanath Singh,
Yes, my lord.
who is the father of this accused,
Yes, my lord.
was served a notice on 14/8
At court premises.
at court premises.
Yes, my lord.
14/8, and when you were, I mean, you were produced before the court in Gauhati?
Gauhati, my lord, subsequently produced, my lord. 16/8, my lord, but he was produced, my lord, 14/8 before the Patna for transit bail.
Okay, Patna for
Yeah.
transit bail.
Yes, my lord, I have right to file the bail application before the Patna.
No. Where is the violation if it is given in 14/8/2025?
Premises, my lord, after production of this person, this notice was given, that is reflected here. Even my lord, judgment of Pankaj Bansal has categorically, it has categorically stated, if it is given at the time of production of the notice, my lord, then it will not full service, right under Article 21.
No, it should be given when then?
Before, my lord, production of the accused person, my lord, he should be given notice, my lord. At very time, my lord, they have stated, I was in the police station also, father, they were not given. And my lord, law is that, my lord. You have to give this.
Law is that it should be given, the benchmark now this Shah case has put 2 hours.
I have categorically stated it was not given. My lord. I am coming, my lord. And secondly, my lord, most important thing is that, my lord, that is important. Father has, your lordship, kindly find 44.
44.
Yes, my lord. Father has signed in, my lord, Hindi language. He is not conversant with that language, English language, my lord. And
But he has written, I mean, 14/3/2025.
yes, my lord.
So he's conversant with English.
Who am I?
14/3/2025.
He has
Yes, my
written
lord.
in English. Siblan Singh, my lord.
Hmm?
Hindi. Vishwanath Singh.
14/3/2025, Vishwanath Singh.
Yes, my lord.
Your client is a clever guy.
No, my lord.
He has put
What is that, my
he has
lord?
put in name in Hindi and put the date in English.
My lord, my humble.
So he, in spite of knowing English, he has put it intentionally in Hindi.
This is, my lord, imagination, my lord. The law is that, my lord, if he does not conversion with the language, my lord, as I, my lord, say, let him prove that that I am conversion with the English language.
To cut the long matter.
And they never denied this thing, my lord. They never denies this thing, my lord.
To cut the long matter.
Who is I mean, the person's name is Anshu Kumar, right?
Yes, my lord, Angshu Kumar. I am father.
Yes, Mr. Chaudhary.
Lordship has taken note of my friend's arguments. And if I may just request your lordship to look into the order dated 22/1 passed by this honorable court.
Which one? Order 22?
22/1.
Yes.
Now, lordship, the assertions made by my learned friend can be verified only with the records. The records have been called for, lordship. It is not before the court. No. I do not think it has come.
Something is there.
Is it? I do not know. I said.
And Sarship is also there, my lord.
Acha. If it has come, lordship can very well verify, lordship.
You want to verify this record?
Lordship, I have to go through it once, lordship.
Mr. Chaudhary, let it be posted in the on Monday. Let him go through it.
Wednesday, lordship, in case I do not see any objection also that has been filed, then I can file my objections by Monday also.
Yes, please file it. See, but let me tell you that, I mean, as far as one ground of section 36,
Lordship.
that ground we have already considered in another matter. So that is there. So now you'll have to, I mean.
I know, I'm on very slippery ground.
Because, I mean, consistently, at least this court is holding that section 36 violation. I mean, he will get
Yes.
right.
Yeah.
But if you can show something else.
Yes.
So we'll put it on Wednesday.
Let it be on Wednesday, Lordship.
Heard Mr. NNB Chaudhary.
She will not be available. Can it be, my lord,
Mr.
24?
Chaudhary, if you are there, why some other people are required to be available?
Well, her
You are
very
alone
said-
sufficient.
her something said.
Then when? Then Wednesday?
24, man.
Huh?
24. इधर तो ना? हाँ? 24 no. दिया है, दिया तो
Oh,
अच्छा,
अच्छा, अच्छा, अच्छा, अच्छा, अच्छा, अच्छा. 24 is fine with me.
24, some other cases are also in.
25, Lordship.
26,
26.
26, 26.
23, my lord.
Hmm?
23.
23 will be difficult. 26.
26, Lordship, I've got a fixed matter in
Month
Shillong.
is-
Yeah, if you-
Or 27 if it is not inconvenient, Lordship.
A long day to, so.
25th not possible. Mr. Chaudhary, see, 25th.
My lord.
25th not possible. First.
My lord, possible, my lord.
So let the matter, heard Mr. NNB Chaudhary, learned counsel appearing for the accused applicant, also heard RKD Chaudhary, learned special standing counsel for NCB.
Lordship, Deputy SGI.
Oh, sorry, the Deputy Solicitor General of India for respondent.
There's only one respondent.
So should I mention NCB? For NCB, then let the matter be listed on 25th, 2/202. You just go through it.
Yes, that was what.
And if
With your
you,
Lordship's permission?
yes, let him go through this. And you file an objection if you.
Yes.
No, objection file for, my lord, I think objection has been filed. Objection file for sir.
Wait, please, Your Honor. Here in this case, FIR Lordship will find page 8.
Here in this case, we have received the CD just now. It was lying in another court. Today, another court same against this same ACD, another matter was picked.
And in that
So,
case,
Lordship, we could not-
only considering the length of detention, he was granted bail in second bail application. Earlier on merit, it was rejected, and on second application, he was granted. I am also on behind the bar for 73 days, Lordship. Same incident, and only what I find subject to correction of my line of defense is, Lordship, that in the forwarding report, it is said that some stolen articles were recovered from the present petitioner. Even in that case, Lordship, Gauhati will not come, and Lordship, then 60 days will be mandatory period. Lordship.
Monday, Lordship, because Lordship, today it is.
60
today
days.
it is-
I mean, now how many days?
Now 73 days.
60 days is the mandatory period.
But if Gauhati does not.
Gauhati is taken out. Let him go through it, then we'll take it up on Monday.
Because today, just now.
Monday we'll take it up.
Before.
Or if your, contention is correct, then Monday will be,
Already other co-accused is granted bail in coordinate best today.
today itself,
In second bail application, earlier on merit rejected, today on considering the length of detention.
length of detention.
And I am also.
So they place it on Monday, same thing, place it on, because you don't have it order now.
No.
Monday you place it. But Mr. A. Ahmed, the learned counsel appearing for the accused applicant, also Mr. P.P. Parasar, PS Locker, the learned APP for the state. You write that Mr. A and Mr. Locker submits that he has received the case diary just recently, and then just some time back, and he needs some time to peruse the case diary. Accordingly, wait for some accommodation. Let the matter be fixed on 23rd, 23, Monday.
The Gauhati to court.
Monday is 17.
Oh, sorry. Sorry, 16. I was thinking, I've given the other one, is it?
Gauhati to? All Gauhati is nahi. 90 days. 90 days all Gauhati है.
38.
Please, Yes, 12 is the affair. Petitioner is interim bail and he appeared before the IO. Case 12 is the affair. My name is not in the affair. I am the owner of a escape material godown. The police has my godown suspected to be stolen, receiver of the stolen property. Nothing was recovered. I am interim was granted. I have appeared before the IO and cooperate with this. Case 12 is there.
Mr. Borua,
My lord.
let him go. Nothing is there.
No, my lord, material is there, my lord, because he's the my lord, habitual purchaser of stolen property, my lord. That material is available in the case diary, my lord. Although, my lord, his statement has been recorded and he has appeared before the IO, my lord, pursuant to the interim protection, but as far as the materials are concerned, my lord, it is available, my lord, in the case diary.
Yes, give me the case diary.
My lord. Itu dia, sorry, itu.
There are some materials against you. Hmm? But you are a purchaser. Only he is implicated, this Jitu Mesh, one person.
Yes, but who are the
Other person didn't know about this.
who are the main accused? They have implicated. One of the main accused has implicated. I blame the city, my lord. Better also there.
And say, let him cooperate. I mean, what is the point of keeping him? Because I've seen, I mean, this Mass has implicated that he is to buy it. But other guys have said like they are not aware.
Other
of.
guys, my lord, he is not known to him, my lord.
No, maybe, I mean, like they were not together when it was sold.
Yes. Question is,
But this property is also worth is very less.
3.5 lakhs, man.
No, nothing.
No, what is the property, my lord? I could not understand, man. Actually, what is it is.
Some cover of some fire extinguisher, something like that. Maybe the metallic part, or something like that. Let him cooperate and go. Heard Mr. S. Islam, learned counsel appearing for the accused applicant. Also heard Mr. R.J. Borwa, learned APP for the state. This is an application you write. The allegations in the FIR are that some materials of Oil India Limited had been collected by some unknown persons, including unknown persons. Full stop. The petitioner, who is a scrap dealer. No, it was you don't write anything. Consequently, the police registered the aforementioned case, and statement of the driver and the vehicle you don't write that, they cut it. An FIR was lodged by one Jintu Das, Sub-Inspector Security Oil India Limited on 11/10/2025, alleging that they have been informed by VDP personnel, Nobo Lama, that at about 8:30 AM on 11/10/2025, they noticed one unknown person loading some items in his vehicle, Tata Nano. And when he tried to stop, the unknown person fled away along with the vehicle. Full stop. Semicolon, that when he checked the indirect heater, flame arrestor accessories, flame arrestor, accessories were found to be missing. It was that the flame arrestor accessories is worth 3,50,000 rupees. Full stop. On receipt of the FIR, police registered Naharkotia Police Station case number 64/2025 under the aforementioned section. Next paragraph. The accused applicant in the instant case is a scrap dealer who has been alleged that he has bought the stolen articles mentioned in the in the FIR, full stop. Full stop. This court by an order dated 15/12/2025 allowed the accused applicant to go on interim pre-arrest bail. Full stop. It is submitted by a learned counsel appearing for the accused applicant that he has already appeared before the investigating officer and his statements statement has already been recorded by the investigating officer. He submits that he is fully cooperating with the investigation, therefore his interim bail should be made absolute. Full stop. The learned Mr. R.J. Boro, learned APP, however, submits that there are materials suggesting the accused applicant to be a habitual offender who buys the stolen articles from various sources, including the arrested, including the main accused, that is Jintu Match, full stop. Therefore, he opposes the grant of bail to the accused applicant. This court has gone through the case diary that has been produced before this court, as well as heard the submission made by the respective counsel. After, in consideration of the fact that the accused applicant has already appeared before the trial, already appeared before the investigating authority and cooperating with the investigation, this court is of the opinion that the interim bail so passed by the order dated so and so should be made absolute. Accordingly, the instant bail application is disposed of by making the same absolute in the same terms and conditions mentioned in the order dated. Accordingly, disposed of CD to be sent back.
39. We have received the case diary.
Hmm?
Case diary received.
Case diary received.
Find the FIR at this time.
FIR at?
Just 10, 1 0.
This one.
You are in interim mode.
Oh, my lord, fact is that, my lord, admittedly there was love affair between the victim and the victim. Victim is 16 years old and the petitioner is 25, my lord. And on the day of incident, my lord, she, on her own volition, my lord, came to my house. My mother informed her mother, the informant, that your daughter has come. Kindly take her back. Then, my lord, there was some altercation between them. And, my lord, after some days, my lord, on 27/6, my lord, this FIR, my lord, she lost this FIR. And on the day, my lord, when she came, her relatives, my lord, took her back. And as per the FIR, my lord, she was handed over to an NGO. This is the case. My lord, the petitioner, case of the petitioner, my lord, there was no physical relation at all in that. The petitioner's mother and other family members are there in the house. It cannot be. My lord, it will reveal from the medical reports.
Mr. Borua?
The medical report is not available along with the case diary, my lord.
No, I mean her statement.
Her statement is there, my lord. She is aged about 16 years, my lord. She said, my lord, her both parents, my lord, left her and her brother.
There is no accusation against him.
Then, my lord, she went to the, my lord, she is having some love affair with the, my lord, accused person. So she went to the house of the accused. There her marriage was solemnized, my lord. And thereafter, my lord, they lived as a husband and wife, my lord.
No,
But at the
there's
same time, my
nothing,
lord,
nothing against him. Nothing, no allegations against, not a whisper.
only, my lord, her consent is, my lord, not valid.
And like there is no allegation of any physical assault.
That is not there, my lord,
Mm.
because in the 164, 183 statements, it is not there, my lord.
Not there. I mean, there was no, I mean, there was nothing, no allegation against him. Purely this thing. Only thing is that she's a minor.
My lord, and only, my lord, she has stated, no, 183, my lord, মোৰ আৰু দীপ নেওগৰ মাজত শাৰীৰিক সম্পৰ্ক হৈছিল. It is her, my lord, her only, my lord, consent is not valid, will be treated as valid, my lord, considering her age.
At any condition, I cooperate with the informant also will take care.
Let him go.
Objection may be recorded, my lord.
I think this is not a case where you should object.
The question is that, my lord, her age, my lord, because if they are solemnized marriage also, my lord, that will
You,
amount
you,
to
you see,
age, my lord, again.
I think this is there. I mean, the age is also.
Her date of birth is also, my lord, says, my lord.
Hmm?
Her birth certificate also says, my lord, her date of birth is 10/11/2009, my lord. So admittedly, my lord, says minor.
Let him cooperate, let him go. Mhm. No, it is not a typical case of, I mean.
Sexual assault part is not there.
Sexual assault is not
That
there.
part
It's
is
not an offense of rape is not there.
Not there, my lord.
So only thing is that maybe, I mean, she was enticed and like take it, that may be there. I mean, we are not sure. But Mr. Francis,
He is appearing for the informant.
You have anything to say? You are, what, why?
I have instruction not to oppose the bill.
He has heard Mr. So-and-so, the learned counsel appearing for the accused applicant, also heard Mr. R.J. Borua, the learned APP for the state. Also Mr.
M.I. Hussain.
As well as M.I. Hussain, the learned counsel appearing for the respondent number 2. Respondent number 2. This is an application under so-and-so. Then you write, an FIR was lodged on 27/6/2025 by one Srimati Janmani Lahon, the informant, before the officer in charge, police outpost Talab, Dumduma, alleging that her minor, her daughter of 16 years old was abducted by the accused applicant on 13/6/2025, giving false promises of marrying her and took her to his own residence. Full stop. Full stop. It was alleged that the informant's relatives, with the help of police, managed to recover her daughter. But since she was not present at that moment, she was handed over to one NGO. Full stop. She alleged that the accused applicant was absconding at that point of time after committing the heinous crime. In view of the aforesaid FIR, police registered Dumduma PS case number 111/2025 under the aforementioned sections. Full stop. The learned counsel appearing for the accused applicant submits that the accused applicant and the victim girl were in a love relationship, and since the victim girl wanted to get married to the accused applicant took her to their house and solemnized the marriage with her. He submits that there is no sexual assault committed by the accused applicant on the minor girl, and the minor girl in fact voluntarily came to the came along with the accused to the accused applicant's house. Full stop. He further submits that the accused now you have come to some understanding of what? Is there any understanding of marriage or something?
Maybe there may be.
But you don't have any instruction.
My instruction is there is equitable settlement going.
Okay. He submits that the family of the victim girl and the accused applicant, some talks are going on for an amicable settlement between the parties by way of a marriage. By way of a marriage or what? Marriage talks or something else? Because you said you married her, but you said you married her.
No,
She made a statement probably.
her statement may be valid, but no, I have no instruction.
You don't have any instruction. But she said that নিয়ম অনুসারে বিবাহ সম্পন্ন করে. She said that like she is married to him.
I have.
He submits that the accused applicant, being a young boy up to how many years? 25 years old, and he did not have any intention to harm the victim girl, and he is agreeable to cooperate with the investigation in the instant case. He should be allowed to go on pre-arrest bail. Full stop. The learned Mr. R.J. Boro, the learned APP, on the other hand, submits that there are certain incriminating materials against the accused applicant. Therefore, he opposes the bail. The learned Mr. Your name? Mr. M.I. Hussain, the learned counsel, appearing for respondent number 2, submits that he does not have any objection if the accused applicant is granted pre-arrest bail in the instant case. Full stop. After hearing the parties and taking into account the materials brought before this court, as well as the statement made by the accused, the statement made by the victim before the police, no?
This is 183 statement.
183 statement made under 183 of 183 BNS or CRPC. This
BNS is
183 BNS is the
earlier 160.
earlier 160. BNSS. This court is of the considered opinion that this is a fit case wherein the accused applicant should be given the privilege of pre-arrest bail. Therefore, it is directed that in the event of the arrest of the accused applicant by the investigating authority in connection with the instant case, he shall be allowed to go on bail on furnishing of bail bond of ₹20,000 with a surety of like nature to the satisfaction of the arresting authority subject to the following conditions. Just put 2, 3 conditions. In view of the aforesaid direction, the instant AV application is disposed of.
40.
CD has come.
Yes, I received, my lord.
Email.
Hmm?
Number 1. Right. Approximately 18.
Page number?
18.
Allegation is?
Detail loaded truck, I'm from Biota, close to Gauhati. Driver individually arrested, they were ended on bail,
You are the?
I am for the cattle purchaser and vehicle owner.
You are the vehicle owner and purchaser. And driver has been allowed on bail. And you are in interim.
Petition number 1, 1 is interim.
Petition number 2?
Petition number 2 is not interim. He is a vehicle owner. I have indexed all the received matter. Page 20 matter and just landed prices matter, cattle and matter.
Page 20 is what? 20 is what?
Zima. Matter.
Page 20 is what?
20 minutes.
Receipts. And these cattle were recovered from the truck. And yeah, where is the certificate of veterinary department?
Cattle have been given Zimmer the Cattle have been given Zimmer the
Jimma has been given to the Mr. Borwa?
My lord.
Jimma has been given already.
Yes, my lord. What happened, my lord? 44 numbers of cattle were recovered, my lord. Then, my lord, while checking, my lord, 6 was found dead, my lord, because they carried the cattle in such a pathetic condition, my lord. 6 died, my lord, in the vehicle itself, my lord. Then remaining 38, my lord, police has recovered, my lord, and it was, my lord, kept in a, my lord.
So, I mean, now thing is that Mr. Borwa boils down to this. I mean, Jimma has been given to him, the owner only,
My lord.
the cattle. So there is no question of, I mean, not owning the cattle by him. That is admitted fact.
My lord.
The only thing is that now, he was transporting this cattle in a pathetic condition or whatever, inhuman condition or whatever, and the cattle died. And for which, I mean, there is punishment, then he has to face the trial. Correct. Now, at this stage, putting him inside jail is not.
No, my lord.
I mean,
my submission is, my lord. My submission is that, my lord, while they, my lord, carries some cattle, my lord. Yes, but there is no bar, my lord, carrying cattle, my lord. But they have
The inhuman
carried the proper documents, my lord. My lord, lordship has already stated, my lord.
documents, no, now the Jimma has been given.
Jimma has been given, my lord, that is after while the, my lord, truck was intercepted, my lord. They could not produce any documents, my lord.
No,
Because,
correct.
my lord,
Now,
when
now,
they purchased the, my lord, cattle,
no,
they
correct.
should have handed over the documents to the, my lord, first driver, my lord. Thereafter, my lord, veterinary fitness certificate would be required.
No,
So that
those
the
were
cow
not
can
there.
be-
Those were those were not there. And for that, like if he will, I mean, he will face the trial.
That is why, my lord, primary basic materials are there, but because, my lord.
No, that is why he will face the trial for that. Now, I mean, why you need to put him inside? That is the thing, no?
No, my lord, our intention is not to put him inside, my lord. My submission is that, my lord, while, my lord, carrying those cattle, my lord, the owner of the cattle, my lord, who now produced those
So,
documents, my lord.
admittedly, he has committed something.
Yes, my
Has
lord.
committed. He has violated that Assam Cattle Preservation Act.
Preservation Act.
That is, he has violated, and for that he definitely face the trial. And if he is found guilty, he will be fined or he'll be put behind the jail, whatever. But at this stage, when Jimma has been given to him of the cattle, what will you do with him? That is I mean, that has to be considered by this court. But only thing is that like, you carry those cattle. I mean, in such a condition, the cattle dies.
And they never, my lord, they never handed over the documents to the driver, my lord. Lordship will find in every case, my lord. After that, my lord, when the cattle is intercepted, my lord, then only they comes with the documents, my lord. That no, I have purchased those cattle from this person, from that market.
heard Mr. Secretary, the learned counsel appearing for the accused applicants, also heard Mr. R.J. Borwa, the learned APP for the state. This is an application so and so. The allegation as alleged. Allegation as narrated in the FIR dated 10/12/2025 is that on 8/12/2025 no, on 9/12/2025 morning at about 4:40 AM, when the police team, including the informant, was in a patrolling duty near Dhopatari Bazaar, a driver of unidentified four-wheeler came and informed them that a truck coming from Gauhati side towards Gauhati was being driven in excessive speed and in a reckless manner and attempted to collide with the said four-wheeler vehicle. The patrolling staff immediately stopped the truck and intercepted the same. On questioning the driver, the police team learned that the truck was loaded with live cattle. When asked to produce the relevant documents relating to transportation of the cattle, the driver failed to produce any documents. During the search, 38 cattle were found alive and 6 cattle were found dead, and all total 44 cattle were found in severe condition. It is alleged that the driver and the handyman were illegally transporting the cattle to another state in a highly unsafe manner by overloading the animals and covering the truck with overloading the animals. It was suspected that the cattle might have been stolen from unknown locality. After receipt of the FIR, Changsari PS case number 236/25 under the aforementioned section was registered. The learned counsel appearing for the accused applicant submits that the cattle were transported legally with proper documents by the owner of. You were transporting, right? In your own vehicle?
No, you get page number 2 to the
Hmm?
page number 2 is the vehicle number.
Petitioner 2. And petitioner 1 is the
Cattle purchaser.
purchaser. That the petitioner number 1 was purchasing, was transporting the vehicles, transporting the cattle with proper documents. Proper documents and the accused applicant number 2 is the owner of the vehicle. Full stop. He further submits that the accused applicant number 1 has already has produced the required documents of purchasing of the cattle, and thereafter he has been given jimma of the cattle by a competent court. He further submits that the applicant number 2 is the owner of the vehicle, and he does not have any connection with the transport or with the purchasing or transportation of the vehicle, full stop. In view of the aforesaid, he submits that the accused applicants, in view of the aforesaid, he submits that the accused applicant number 1 has already been granted interim protection by a coordinate bench of this court, and accordingly he has already appeared before the investigating officer, full stop. He submits that the accused applicant number 2, being the owner of the vehicle, will owner of the vehicle will cooperate with the investigation in the incident case, full stop. The next, the learned Mr. R.J. Borwa, the learned APP appearing for the state, the learned APP submits that the cattle were in fact being transported in an inhuman manner, and thereby killing 6 cattle. 6 cattle. Therefore, 6 cattle, and when questioned by the police, they could not submit any document at that point of time. Full stop. Therefore, he opposes. Therefore, he opposes the anticipatory bail sought for by the accused applicants. Full stop. Next, this court has gone through the case diary that has been produced before this court, and also heard the submission made by counsel appearing for the respective parties. Full stop. In consideration of the facts in entirety, this court is of the considered view that accused applicant number, who has already appeared before the investigating officer, in terms of the interim protection given by this court, given by this court on 21-1-2026, should be made absolute. Full stop. In same terms and conditions mentioned therein. As for accused applicant number 2, this court is of the view that in the event of his arrest by the arresting authority, investigating authority in connection with this case, he shall be released on bail of rupees 30,000 with a 30,000 of furnishing a bail bond of rupees 30,000 with a security of like nature to the satisfaction of the arresting authority, subject to the following conditions. You put some conditions there. In view of the aforesaid, the instant bail application is disposed of. But something needs to be done of this cattle thing.
This is a regular manner, my lord. Lordship will find in every cases, my lord, whether kettles are, my lord.
How many matters are there?
No documents they could provide.
No, we'll take up these matters. We'll take up. But counsels are there, then we'll take up these matters. All of these are there. Yes.
Maybe allowed to withdraw the bail application.
Okay. I heard Mr. S. Ahmed, the learned counsel appearing for the accused applicant. He submits that on instruction, he wishes to withdraw the instant bail application. Prayer is allowed. The instant AB application is closed as withdrawn.
Okay. 44.
I think CD receipt, lordship, in this case, lordship. Report fixed date next week, lordship, on 20 February, lordship.
Okay, heard Mr. A.R. Karim, the learned counsel appearing for the accused applicant. Applicant CD received. Let the CD received. Let the case be fixed on
20, lordship.
fixed on
20.
20th. 20th.
It may kindly.
20.
It may kindly.
CD will be written.
Obliged.
CD, sorry, CD will be written.
45 CD we have not received.
Did you not receive?
Okay, sir.
Here, FIR, your lordship will find page 15.
Can it be heard today?
A small matter, lordship.
Small matter?
Yes.
Then
In the
we'll-
FIR, there is no allegation against the present petitioner, nor his name in the FIR.
Hmm.
And one person that your lordship will find the name, top lordship.
That's,
from-
sees narcotics.
Yes, that fourth line lordship, that Abul Azhar.
Hmm.
From his motorcycle, there was information that he was carrying narcotics, and accordingly from his motorcycle, from his possession, it was recovered. So there is no other allegation against the present petitioner lordship in the FIR.
How he is implicated?
Now lordship may kindly see
Hmm.
page 20, that is important. That is the part of the forwarding report of that arrested accused. In
Page,
that
page 20.
Page 20.
Hmm.
That arrested accused, that grounds are mentioned. Here also lordship will not find my name that any connection with the present petitioner.
Hmm.
On the ground number 3, lordship may kindly see.
1 second. Ground number 3, yes, during
During
interrogation.
interrogation, arrested accused person admitted his guilt
Hmm.
as he transporting the suspected to the Yaba tablet from his house.
Okay, got it now. Now, how you are implicated? You got implicated.
Yes, and why I'm referring to this ground lordship, he
Hmm.
says that he was supposed to deliver to 2 unknown miscreants,
Oh,
unknown
okay.
ladies.
Mm-hmm.
That is. So
Hmm.
my name is nowhere mentioned, and surprisingly in the charge sheet I am shown as absconder lordship, and it is said that in confessional statement he named me. Page 31. your lordship is-
Confessional statement of this person.
Yes.
He
Page-
named you.
Yes.
So that's how you got implicated.
Lordship.
That's what I'm asking.
At initial point of time, there was no implication of in the confessional statement. That is
No,
what I-
obviously that will not be there. Now, I mean, ultimately, I mean, he has implicated that you were the person whom he was supposed to deliver it.
No.
Hmm?
From me, he has purchased. That is the allegation.
Or from you, that has been purchased. Hmm.
Receipt, not receipt.
The receipt means purchase or whatever. I mean, like you are not doing charity with drugs,
Lordship.
obviously.
Now, page 31, that is the part of the charge sheet. Lordship will find that.
So what is your ground of, I mean, this thing?
For bail, lordship, I am on the ground that apart from the confessional statement, there is no material to connect me with the alleged offense. Lordship. Now, charge sheet is submitted, he is intending to face the trial, lordship, whatever is there, lordship. And for the probably custodial interrogation is not required. Now, charge sheet is submitted, he may be protected. I am relying on lordship, some Supreme Court judgment and coordinate bench judgment of our High Court, lordship. Lordship, may I kindly see the Supreme Court judgment which I have given, lordship, thereafter I will place the coordinate bench
So
judgment.
what is the ratio there?
The confessional statement of co-accused is not sufficient to reject that bail, lordship, that other material has to be there, apart from that confessional statement.
Okay, where is Jugraj Singh, which?
Paragraph 4, 5, 6 and 7. Paragraph 4, lordship, may I see that the material which is against the person.
You are in interim mode.
No.
So para 4, 5, 6.
Then, sir. Regarding medical graphic.
No, here is like situation is a little bit different. I mean, he joined the investigation.
Because you say after filing of charge sheet, he approached the court and court granted it.
No, so that's a different effects.
And then you see that Sandeep Chandra, in that case, lordship, he was discharged from the service because only that confessional statement was there.
Actual position is
In that case, some narcotics were recovered from his premises, and Supreme Court held that for that purpose he may be tried, but regarding 27, only on the basis of co-accused statement he cannot be tried. I mean, next case notice that Rambali Sani, paragraph 7 and 8. Here initially High Court granted bail, subsequently the same court cancelled the bail, and on that aspect, Supreme Court held that promotional statement is not sufficient for recalling that. Paragraph 7.
But herein, in all these cases that you're submitting, this is anticipatory bail.
Last that Rajesh Bhagat also anticipated bail, they are also granted. And now I have given the coordinate that so that your lordship's order is also there.
Yes, Mr. Borua,
Yes, Lordship, may I kindly come to page number 31, my lord.
page 31.
31, my lord. 31, paragraph number 17, my lord.
31 is what? 31?
That one is the part of the search sheet, my lord.
Yes.
Lordship, may I come to
Paragraph?
paragraph number 17, my lord, page
Ah.
number 31.
Hmm.
Down below, my lord. My lord, I'm just reading.
Hmm.
Person is accused, FIR accused person is confesses guilt. On the other hand, he was caught red-handed along with narcotics contraband suspected to be yaba tablets, drugs, and the FIR accused person, Abdul Azad, also stated in his statement that one of his inmates, namely Babul Hussain alias Babul, has gave him the said huge quantity of narcotics contraband to supply the same to two unknown ladies of Sri Krishnanagar near Indian petrol pump. And my lord, I have also verified from the scan copy of the record, my lord, in his statement of the, my lord, the accused person from whose position, my lord, narcotics drugs was recovered and seized, my lord, he has also implicated this person, my lord. Now, my lord, these are the organized crime, my lord. One has to supply and somebody, there has to be somebody, my lord, who will receive the contraband.
Any other material,
Other material, my lord, from the scan copy, I have not found, my lord. Only, my lord, the statement, apart from the statement of co-accused statement, my lord, I have not found from the.
do you want to go through this?
Let me
We'll,
come
we'll fix it on Monday.
Monday or let it be Monday, man.
Let him go through this, Mr. The allegation is serious.
So I have gone through the case record.
But see, if there are materials against you that you have been in touch with him, or there are certain other materials connecting him with him, then that has to be considered in a different way. So let him go through this.
I will only go through, my lord, whether any connection between them is there or not.
You'll need the case laws, or you'll put it here.
Lordship can keep it in the file.
I'll keep it in the file. Then. I heard Mr. A. Ahmed, the learned counsel appearing for the accused applicant. Also heard Mr. R.J. Borwa, learned AP for the state. Let the matter be listed on
16. Monday 16.
16th. 16th.
Item 46.
Next week.
So we'll give it a date. Heard Mr. S. Islam, the learned counsel for the accused applicants. Also heard Mr. P.S. Lockhart, learned APP for the state. Let the matter be listed on
20,
Yeah,
2020.
20 will be difficult, 23rd, 23rd.
CD we have not received, that will be bring.
CD so received, to be
Not-
retained.
we have not
No,
received.
oh, CD not received. CD not received in this, CD not received. No, don't write CD not received. It's fine. We'll list it on. If you can-
23rd.
Hmm?
23rd.
Hmm.
Bless.
CD has come.
CD we have received.
So we'll post it some other day. Okay.
Not.
Heard Mr. SM Abdullah, SM Abdullah, SM Abdullah P, the learned counsel appearing for the accused applicant, also PS Locker, learned APP for the state. Let the matter be listed on. What is the matter?
Matter is regarding
Cattle.
transportation of cattle, but I am neither related with the transportation, nothing.
You are also involved in
No,
transportation of cattle.
No,
Okay, we'll fix it on, we'll
Yes,
fix
it
it on
is that
Monday.
I helped the driver in filling from the place of occurrence, madam. Lordship, I fix it on Monday, Tuesday.
Come up with good cases, Mr. Abdullah.
No,
All
possibly
cattle.
this is a good case, madam,
Mm.
but Lordship will fix it.
Let the matter be fixed on
17.
18th.
Oh.
18th.
Oblige, your Lordship.
48.
Forget Lordship, regarding, here in this case, we have received the CD, but Lordship, the CDI report was called for. That is, that we have not received. So we need some 1 week type Lordship. So it could be.
Some protection will be granted, Lordship. Here is the.
No, we'll hear it in the next date. I mean, on a small this thing. I mean, short date we'll give.
He is the only owner of the vehicle where Lordship, that some Erica not sure found, and he has given it on lease, Lordship. That agreement I have also enclosed.
You are till now you are not arrested. I don't think you'll be arrested. I mean, in couple of days. So wait for 2-3 days. Let it come. Okay. Heard Mr. E. Ahmed, the learned counsel appearing for the accused applicant. Also heard Mr. P.S. Locker, learned APE for the state. Learned APP submits that what is not the come CDR. The CDR, which was called for. Which was called for what?
It was called for Lordship, but it is not received. Lordship.
Yes, that's.
No, it is not called for.
It was not
It was called for.
CDR, though the CD has come.
CD we have received.
Though the CD has been received, CDR, which is required in the instant case, is yet to be received. Let the matter be fixed on 19th. 19th.
Lordship.
On 20th, Lordship, because it has to come.
Okay, 20th.
Oblige.
This is your problem. You can keep it.